Koutou katoa. We'll get underway again this morning for the second day of hearings on the proposed Timaru District Plan. This is hearing stream A, where we're dealing with the introductory matters, some definitions and their strategic direction parts of the plan. This morning, first up, we have Canterbury Regional. Please come and take a seat. And Ms. Francis. Thank you. And just a reminder that the hearings are being live streamed and the recordings will become available on the Council Planning website in due course.
Tēnā koutou katoa, ko Deirdre Francis toko ingoa. My name's Deirdre Francis. I'm appearing before the hearings panel on behalf of Canterbury Regional Council. Thank you for the opportunity to present to you today. I think I circulated what I'm speaking to now, where it talks about this one correction to my evidence. Just confirming that. My purpose for attending today...
Supposed to have a summary.
Wasn't there? Okay, Josephine sent it through yesterday.
Is it on the website or is it, because we can locate it quickly if it's
she emailed it.
Just give us a couple of minutes to catch up with you and then we'll...
I do have other copies, they're just not in the right format.
No, just bear with us.
No, it's not on the website.
Ah, it's not on our list?
What's it up? I do have copies here that they're just not in the format they're supposed to be in.
That's right. We'll go to your primary brief of evidence, and if you can just tell us what the correction is, we'll make a note of that now, and then you can read out your summary and we'll catch up with the paperwork after the... No problem at all.
On page 13 of my evidence, in paragraph 60, I refer to the Timaru District Council Growth Strategy Review. I've said that this review recommended densities to be a requirement of developing the proposed greenfield areas in the proposed Timaru District Plan, and the footnote for that refers to section 9.3.1 of their report. While that section does discuss a minimum density, the recommendation to require a minimum density standard in the district plan is in section 5 on page 10 of their report. You'll find it under amendments to draft district plan number D. My purpose for being here today was to answer any questions that you may have in relation to my evidence. I've nothing further to add to my evidence. But in summary, my submission supports most of the recommendations made by Mr. Willis in his section 42A report. In paragraph 15D of Mr. Willis's summary statement, I note that he says the request for changes to the future development areas chapter can be considered in the future development area hearing rather than this hearing. So I just wanted to clarify whether you want me to talk about those parts, or if you want to ask me questions about them today, or if you want to wait for that future development area hearing.
I have just a couple of questions of clarification to ask you about that, but I was going to also ask you whether you were returning at a later date, because
I believe I'll be a frequent visitor.
excellent. Look forward to it. So, yeah, just complete your summary and then, yeah.
I've made recommendations for additions to the future development chapter to better align the introduction and objectives of that chapter with its policies around rural lifestyle development, and I believe that will also better align the strategic direction, urban form and development in future development area chapters. I've also made a recommendation to include a minimum density policy for urban areas in the future development area chapter, and I believe this will also better align strategic direction, urban form and development in future development area chapters, as well as giving effect to the NPS UD requirement for well-functioning environments and reducing pressure on highly productive land. So that basically concludes my summary of what I've covered in my evidence. I'm happy to answer any questions. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
I've just got two questions. I just want to turn to paragraph 28 in your evidence first and use the term the TDP is not inconsistent with the CRPS. I just want to check with you that you haven't got any issues around it not giving effect to.
Which paragraph, sorry?
At 28.
28. I think the reason that I used that terminology was because initially our submission said it was inconsistent because it used the reference to important landscapes and features rather than the outstanding ones. So, no, I have no concerns about not giving effect.
Great. And then paragraph 70. And this is where you talk about the new policy. Mm-hmm. And I know it might be given things that might come later. I just wanted to ask you, but had you, particularly around your point B, that there's no policy guidance about some of the concerns that were raised in response to Mr. Willis's report, have you given consideration, or is it likely that you will at future hearings, consideration to potentially having a policy that actually does provide guidance and around a yield that actually isn't specified as a set number within the strategic direction?
I hadn't at the time of writing my evidence, but after some discussion with TDC staff yesterday, I think, yes, there is a possibility that that could be an alternative solution.
Thank you. They're my questions.
I have no question.
Kia ora. I only have one question, and it relates to the minimum yield paragraph 50. And it's really just a question of clarification, because you do say that the requested policy was to apply to FDAs in the anticipated general rural zone. And at paragraph 71, you go on to say that ECAN's only concerned about the new urban development. And what I wanted to know is what zones does Environment Canterbury seek for the minimum yield to apply? And in particular, I wanted to know whether it would be a request for it to apply to the Māori purpose zone or some of the special zones.
Okay, you have to forgive me, I'm actually a bit deaf, so I'm struggling. So if I haven't captured what you said, please correct me. What the Regional Council is concerned about is where there are future development areas that will become urban areas. So in the land that's adjacent to Timaru in particular, which is on the, particularly where it's on the HPL soils. Did that answer your question?
Yes, and I think that will probably get into the depth of it in those future hearings in any event. So, yeah, thank you.
I think you may have already answered my questions. They related to your response.
in the summary statement around the FDA chapter, but it sounds like you've accepted that it's probably appropriate to consider those specific changes in that further down the track.
Yes.
And I think I recall in your evidence in chief that you're satisfied with the recommending officer's change to the UFD 01 provision based on your relief sought.
This is the one where Mr. Willis was recommending adding something about out of sequence.
Unanticipated. Yeah, so it's in the section 42A report. The reporting officer, Mr. Willis, has included that at clause 12 of UFD 01 settlement patterns.
Yes, I think I actually did say that I supported his submission.
Yes, I recall
His
that as well.
recommendation.
Okay, just wanted to confirm that.
Okay.
Thank you.
The panel that was overlooked yesterday, so this is a correction.
Thank you.
Ms Francis, can I just ask you also about the minimum yield requirements and the policy that you've proposed in the plan, and it may become apparent in the later hearing, but can you just explain to me how that policy would be implemented? You've answered a question about the zones that it may apply to, but what's the rule framework that you imagine would hang off that policy? How would it be implemented?
I think possibly something along the lines of where a development plan indicates that the density of the proposed new development will be at 12 households per hectare, that perhaps that could come in as a controlled activity rather than a discretionary activity, something along those lines.
And then if it didn't meet that density, it would default to fully discretionary, or would it be non-complying?
I haven't given that much consideration at this stage, but it would definitely default to a different status, yes.
I also just noticed that in paragraph 14 of your evidence, you've set out the statutory tests, and you have indicated that you've worked through that process in the context of a 32AA approach to your recommended changes. I'm just not clear from your evidence in chief that's before us now, where you address matter G, whether the policy is the most appropriate way to achieve the objectives, having regard to their efficiency and effectiveness, and particularly the benefits and costs of the proposed policy. Have I missed that, or is that something that would come later?
Certainly, if I have missed it, it would be something that will come into the...
Perhaps if I could just signal that that's going to be very important to us. If you're proposing that policy and a series of provisions that would speak to that policy, it needs to, you do need to provide us with a full Section 32
Yep.
analysis of that. I acknowledge that you've addressed the policy setting, the higher order document setting for recommending that policy, but it's just understanding how that would be implemented and what the consequences of that would be. Thank you. I have no other questions. Fine. Thank you. Thank you for your presentation.
Thank you.
And we look forward to seeing you in later hearings.
Thank you.
Our next submitter is Opuha Water Limited, Julia Crossman. Thank you. Welcome.
Tēnā koutou, Commissioners. My name is Julia Crossman and I am the Environmental Manager at Opuha Water, which I will refer to herein as AL. Thank you for the opportunity to present to you today. Owl owns and operates the Opua Dam and Lake Opua, as well as downstream irrigation infrastructure. I provide an overview of the scheme in my evidence, and I will not repeat that here, but will be happy to take any questions to further your understanding of the scheme if required. Owl made a primary submission and further submission on the proposed Timaru District Plan, and my evidence provides a summary position on the matters addressed in these submissions, falling within the scope of hearing stream A. As you'll see from my evidence, most of Owl's submission points were either accepted in whole or part by the reporting officers or were responded to in a manner that has addressed our concerns. My evidence focuses on two submission points that the reporting officers' recommendations did not fully respond to, where the reporting officers' recommendations did not fully respond to the concerns we raised. These are firstly submission point 181.8 and 181.12 concerning the approach taken in the PDP to defining terms, and secondly submission point 181.22 concerning objective SD05 relating to mana whenua access to sites and areas of significance and to carry out customary activities in accordance with Te Kaka. I will now address these in turn. Submission point 181.8 and 181.12 relate to what was phrased yesterday as the functionality of the plan. In preparation for this oral submission, Owl again reviewed this functionality relating to the hyperlinks and believe it's markedly improved since the plan was first notified. In drafting our submission, our primary submission in response to the notified plan, we had many frustrations with hyperlinks not working. These appear to be rectified, and so in response to Ms Hollier's request for actual examples, we're no longer able to provide any. We do, however, urge council staff to undertake a thorough review of all links prior to the final E-plan being published. In relation to the explanatory note, this is not a die in the ditch for us, but it's simply a suggestion to improve the functionality of the plan, and I believe it would assist both plan users and those administering and enforcing the plan. Submission point 181.22 is related to SD05 mana whenua. Owl acknowledges the importance of retaining and enhancing access to sites for customary activities. However, we are concerned that public access cannot always be available due to health and safety obligations. The primary concern for Owl is in relation to our regionally significant sub-scheme infrastructure. The nature of the intakes, the weirs, the irrigations and the like, irrigation races and the like, mean that water movement and flows can change rapidly, and the operation of gates and other and the mechanical structures can pose a risk to health and safety. Owl sought amendments to SD05 subclause 4 and 6 to address these concerns. The reporting officer accepted subclause 4 but rejected subclause 6, which we continue to have concerns about. In response, I have suggested further wording in my evidence that makes it clear that it's a subject to consideration. That makes it clear that the subject to consideration is only provided in relation to the health and safety in areas where nationally and regionally significant infrastructure exists. It is our view that this significantly tightens the clause. In closing, I would like to commend TDC on the huge amount of work that's been taken over many years to get to this point. I thank you all for your time, and no doubt we'll be seeing you again as further hearing streams progress. Thank you.
Thank you, Ms Crossman.
Yes, good morning, Ms Crossman. I just have one point of clarification to ask at your 3.10. Is it the dam that's been an enabler of economic growth in South Canterbury, or is it the water in the dam?
It will be both, but the water in the dam, I guess the water wouldn't be able to be utilised if the dam wasn't there.
So the dam facilitates water movement?
Absolutely, yes. Yeah.
Thank you.
The storage of water, yeah. Thank you.
Thank you. I just have one question, and I'd like to take you to your paragraph 423, and it's your amended wording. So it's actually the top of page. Sorry, I've written over the page number. It's the so what I want to ask you is, how do you see that practically working and this policy practically being implemented? Because I'm assuming there's not going to be a resource consent requirement for access.
No, I mean, my understanding is that if we had to apply for a land use consent to do something with our regionally significant infrastructure or in the area of our regionally significant infrastructure, then this would be a consideration as part of that resource consent process. That's my understanding. So, so whether there's a land use consent process, yeah. So almost a condition of.
So my follow-up question then would be, given the focus of this policy, would that approach is it best addressed here, or would it be best addressed when you're getting into the detail around the provisions that apply to significant infrastructure and what matters might be relevant to a consideration there?
I would have to refer that one to a planning expert as to at what stage it should, where it should be at that higher level, as we've suggested here, or whether it should be at the lower, as long as there's the consistency between the two.
Okay,
Yes.
thank you.
Thank you.
Kia ora, I'll stay with the same paragraph and talking about the change in language of where appropriate should be located in the SASM. No, sorry, SDO 5.
Yep.
And access. And I have two questions. The first is, the reporting officer has expressed that the plan can't override private access rights. So in any event, mana whenua would have to work with private landowners to provide access. So why is it needed in this plan?
I guess it's a certainty. Yeah, that's
Is there a concern that mana whenua will access unless it's in the plan, without permission?
I mean, we've got concerns with anyone accessing without permission. It's certainly not just mana whenua. Yeah, I guess I'm not fully clear on the interaction of the property rights and how that interacts with this. Yeah.
Just seemed quite unusual to me that it was specifically saying mana whenua, and I wanted to understand why mana whenua as opposed to the general public.
Sure, okay. Yeah, it would be, it's a concern for all public, not specifically for mana whenua. Yeah. We would have other fishermen and co-accessing. I guess the provision is related specifically to, this provision is related specifically to mana whenua. Yeah.
So down the track we'd be expecting probably in the public access parts.
Yes, and we did submit on the public access side of things as well. Yeah. And
then my second question was the location of where appropriate, and I don't know if you had the benefit of being here during or hearing Turunanga and Aitahu's evidence, and their interpretation of what the language, it's either retain. So we talk quite a bit about that they either retain or enhance, and what does that mean? And in their view, they said retain was just their existing rights, and when we got to enhance, they still didn't see that as quite as new access. It could be new access.
Okay.
So if we were to accept the reporting officer's recommendation, where appropriate at the beginning of that sentence, it therefore restricts, in Turunanga and Aitahu's view, their current existing rights to access.
I'd have to look at the. So is that in relation to what I've put forward?
Yes. So it's where the sentence currently reads that.
Oh, sorry. I think I follow you now. So yeah. So this would impact their existing.
To retain, yes. The retention of existing access rights. Is that I guess I'm just asking, is that the intent?
No, I guess we just want to protect people's safety more than anything. We don't want to be in a situation where there are, where we do have such, a health and safety situation that we have to deal with. I mean, I don't have any specifics of where we would currently be wanting to restrict, that we want this to address. So no, I don't think it would be about changing what's currently happening. Yeah.
Great,
Yeah.
thank you.
It would be more for new activities. Yeah. Yeah.
Thanks.
Thank you.
Thanks, Ms. Crosman. In your introduction, I noted that you've got planning qualifications.
Yes.
And so one of my questions was the role in which you're appearing before us today. But
Yes.
I just noticed in response to Commissioner that you've said that you deferred to a planning expert.
I wouldn't say I'm an active planner now. No, I'm an environmental manager, which is across a range of things. So
Yes.
consents, compliance, water quality, monitoring, etc.
So your evidence isn't...
Not planning evidence.
Not planning
No,
evidence.
Sorry, I should have made that clear.
No,
I'll
that's
make that
fine.
clear
I
in the future.
thought it's just important
Yeah,
for the record
sure.
to cover that off.
Yeah, absolutely.
Thank
No,
you.
this is general environmental.
Yes, yes, thank you.
Sorry.
So my questions have been covered by fellow commissioners. I did just want to mention that yesterday we heard from Mr Hackart and Collier about the e-functionality.
Yes.
And that came up in questioning and discussion, and they confirmed that that would be very much part of the process, that there'd be a very thorough sweep at the end to check that functionality was a-okay. And I just wanted to note that. And also, just one minor question for me in relation to part one, where you're seeking to have explanatory notes addressing the approach undertaken to defining terms. In your evidence, you've mentioned the Christchurch City plan example. Do you have other examples?
No, that's the only one we were only able to locate.
Okay, so-
But we didn't do a thorough search of all plans.
Right.
Yeah.
Okay.
Yeah.
So what you've put forward is based on,
Yes, it
primarily
is.
based on the Christchurch
Yes, it is.
example? Okay, lovely. Thank you.
Thank you, Ms Crossman. And just picking up on that theme, if the panel wasn't minded to amend the strategic direction objective 5 to address the issue around public access, and or whoever, whether it's mana whenua or general public, and that's picked up in other chapters,
Yes.
would some kind of advisory note or some guide in the introductory parts of the plan that directed users of the plan to key provisions in the plan, would that be an alternative way of addressing the
Yes,
issue rather than amending the policy?
Yes, I think it would be. Yeah.
Thank you. I have no further questions.
Thank you very much. Thank you very much for your time.
Good morning.
Good morning, Morena. You can hear us fine?
Yes, I can hear you well, thank you.
That's
Except
good.
there's a large echo.
I'm not technical
It's
support.
going to make
maybe
it slightly difficult for me to, oh, that's better. Thank you. Thank you, that's fantastic.
We're in your hands.
My name
Welcome.
is Karen Rosser, and I am an environmental planner, in-house environmental planner with the Enviro NZ. Now, Enviro Waste, what became Enviro NZ, I believe, shortly after this submission was put through. So we are now Enviro NZ Services Limited. Enviro NZ Services Limited is second largest solid and liquid waste management company in New Zealand. It owns and operates significant portions of the waste management structure in New Zealand, including landfills, waste treatment facilities, recycling facilities, waste transfer facilities. It operates and undertakes many council contracts to collect curbside waste, to manage transfer stations and manage landfills and recycling facilities for councils around the country, and Timaru is one of those councils. So in Timaru, EnviroNZ operates the Redruth landfill site at 23 Shore Street and 55A and 55C Redruth Street, and they manage that on behalf of Timaru Council. That site comprises a Class 1 landfill, along with a refuse transfer station, a materials recovery facility, an organic composting facility, and a regional office. There's also an upgraded composting facility being built at the moment, and that is comprising some engineered composting bunkers that basically have forced air aerobic maintenance of composting to improve on the existing situation, and so that's something that's also going into Dunedin at some point in the short term. So in terms of what my submission and evidence requested, under the current Timaru district plan, the Redruth site is zoned industrial, heavy industrial, and it has designation for the landfill. Under the proposed plan, the site and its surrounding industrial area is general industrial, and this landfill designation is to be rolled over. And we've been having discussions with the planning staff about that, as the designation currently doesn't include the associated waste diversion facilities on the site. So that's being hopefully looked at shortly. In terms of the what's before yourselves on the chapters being looked at the present time, the request for the Redruth site to be made being encompassed by the definition of significant infrastructure. That's, I understand, regionally significant infrastructure. Understand that's to be discussed at the infrastructure chapter hearing, and I obviously just wanted to confirm that that was, I guess, accepted by the panel at this point, so that I guess we can revisit it at that point.
I'm going to defer to council for the council and just clarify for us which hearing stream that issue will be.
Sorry, I can't hear you.
I'm just checking with the council, and they'll confirm exactly which hearing stream that definition is being dealt with.
Sorry, can you say that again, please?
Yes, it's correct that the definition of regionally significant infrastructure will be dealt with under hearing E. It is the infrastructure chapter.
Okay, in that sense, does the description that we put forward be also considered under that?
Yes, so the description of the district chapter, it just reflects the current definition of regionally significant infrastructure. So The decision that I've recommended in my section 42A is interim based on the recommendations that will be put forward through hearing E when the regionally significant infrastructure definition is considered. So if there's changes to the definition then, they could be pulled through to the description of the district chapter at that time.
Great, thank you. Okay, sorry. Can we have the echo display? Okay, is that, thank you, that's fantastic. Right, so in terms of the strategic chapter, SDO8 is the focus in terms of obviously infrastructure. And there was 2 areas that in my evidence that I guess are outstanding. One is that regionally significant infrastructure is protected from reverse sensitivity effects. And in terms of this, I guess it comes back to whether those types of infrastructure are to be considered important enough to warrant that, and I certainly think they are. In terms of landfills particularly, they're often subject to reverse sensitivity effects, although they have conditions under regional resource consents to create no, mostly it's in terms of odour that the reverse sensitivity comes through. They have resource consents to create no objectionable offensive odour beyond the boundary, but this does not mean that no odour is detected beyond the boundary. And therefore, some people are more sensitive in perceiving whether odour is objectionable or offensive, which is the trigger. And this can often lead to complaints when these more sensitive receivers are perceiving that odour to be a problem. And therefore, protection from reverse sensitivity in the vicinity of waste management sites, it reduces the risk to the ongoing operation of the sites. And therefore, we feel that ensuring the policy framework of the district plan recognises this and can manage the intensification of the surrounding area in the future. This needs to be done through the overarching provisions through the strategic chapter. And this will then allow for the waste facilities and obviously other significant regional infrastructure to continue, and also potentially expand where necessary. It also means that without those overarching provisions, the resource consents can be difficult to be obtained for regional discharges in the future. So that's given the importance of this, we do believe that protection is better than management in terms of reverse sensitivity, because these types of infrastructure are critical to the region, and it's very, very difficult to move them or expand them if they're not, I guess, given some protection under the district plan. And that leads on to whether waste is also considered a type of additional infrastructure, which is my consideration that it is. Under the NPSUD, additional infrastructure is defined as including community infrastructure, which includes land or development assets owned or controlled by the territorial authority for the purpose of providing public amenities. And the site at Redruth would certainly fall under that definition. And I do believe that the strategic chapter should have other types of infrastructure included in that overarching provision. And therefore that's the consideration in relation to that development is serviced by an appropriate level of infrastructure, including additional infrastructure. So therefore, you're not limited to the very confined definition of infrastructure that is in the RMA, and in which I believe you propose to put into the district plan. The additional infrastructure would then encompass some of those other types of infrastructure that are equally important in your district. So I do believe that the Red Roof particularly should be afforded support of the higher order strategic framework, so that it can remain in its current location, and also undertake all the waste diversion activities that are becoming to the forefront. Waste is definitely evolving at the moment. The circular economy is really kicking in with the climate change directives, and it's necessary that all the requirements that the government are putting through in relation to waste diversion are able to be implemented. So thank you. Any questions?
Thank you.
Hi, I've got a couple of questions, and it may be that some might be better at a later hearing on infrastructure. But the first one I do want to ask you about is your paragraph 617, and it's your suggested amendment. So
Yeah.
the including additional infrastructure, what I want to check with you is whether this actually achieves what you think it does. And the reason I'm asking is that this policy appears to relate to development being serviced. And then if you put in including additional infrastructure, the last part is that effectively meets the needs of that development. So I'm just wondering, when I was reading that, and I'm interested in your views on it, it would lead me to the view that were waste included, it would only be waste related to that particular development that would get considered under this policy?
I think obviously development, it can also apply to new areas of development in the district, areas where there's new residential growth happening. So that to me also means it's not just individual sites we're talking about in terms of my understanding of development would be broader than just an individual site. So I do consider that it can apply to the wider needs in terms of the holistic look at the district in terms of development and future growth.
Okay, so can I just then turn you, and I'd like to just clarify on that, get your view on what the last two words of that mean in terms of what that development, what does that mean to you?
That development could be, or it could include. I see where you're coming from.
I'm just wanting to understand
if
it does achieve what you are seeking. That's all.
It could be potentially better worded, but I think it will encompass, I believe, any growth that does occur in the district.
Cool, thank you. So I now just want to go to, again, same paragraph, and I just want to get an understanding from you. I understand in your evidence that you consider, the waste aspects could be additional development. Additional infrastructure, sorry. What other things could be additional infrastructure if we did make this amendment?
Well, it has to be under that definition. Under the SPNU, there is a defined definition under the MPSUD. I haven't got the full definition with me, but I can quickly look it up. Bear with me. So additional infrastructure means public open space, community infrastructure as defined by Section 197 of the Local Government Act, land transport, social infrastructure such as schools and healthcare facilities, a network operated for the purpose of telecommunications, and a network operated for the purpose of transmitting or distributing electricity or gas.
Cool. Okay, and that's what you were meaning there.
So I guess so the additional stuff would be public open spaces and schools and healthcare facilities in addition to what's normally considered infrastructure.
Okay, cool, thank you. And then my last question is a bit more of a general one. And just as someone, because I see you have got some planning knowledge, I just want to know that in a statutory sense, what's your view on if there's a distinct definition that applies to the exact activity you're looking at in the, say, the Resource Management Act, about then through a district plan changing that definition? I understand the logic tree that you've gone through, but I just want to ask, you know, for someone with some planning knowledge, what you actually think about that approach.
I think the infrastructure definition is an interesting one. It does allow for a broader definition, I do believe, in the fact that it does have some common knowledge associations of infrastructure. And I do consider that if you do it in the right way in the district plan, you can include the definition to be just, if it's looked at it might not apply to the rules per se, but it would only apply to some of the policies if it's looked at in the right way. So yes, I have seen it elsewhere in other district plans that it is considered additional. There are opportunities which I'm not sure. I mean, it's potential in other places that, particularly in relation to the definition that was proposed in Natural and Built Environments Act, that regionally resource recovery facilities and landfills were included in the definition of infrastructure. And obviously that act's been repealed. So it was on its way to including waste facilities. But in this sense, now we're, I guess, back where we were. I do believe that you can have, for example, additional infrastructure as its own specific identity or definition, and you've still got the normal infrastructure definition applying specifically for certain areas of the plan.
Okay, so then just to follow on from that, and I know we're not dealing with the detail now, but it's kind of, I'm curious to get an understanding of where this might go. So are you envisaging then from that answer that there might be different rules and provisions that apply to additional infrastructure versus other infrastructure? Is that kind of how you see it playing out?
Yeah, well, I think the infrastructure section usually has rules that are specific to, you know, telecommunications and pipe networks. So those can be specific, and I think there are at the beginning of that chapter certainly some disclaimers that what that applies to. So yes, I believe that you can separate those roles out easily.
Okay, thank you.
Yes, Ms Rossa. At your paragraph 5.6, I just want to ask you a question around your amendment to include protection from reverse sensitivity effects. If an adverse effect includes reverse sensitivity, how does your amendment provide more protection from reverse sensitivity?
Sorry, just trying to get. Sorry, the echo is.
So I'm asking if an adverse, is that better? Can you hear me better? If an adverse effect includes reverse sensitivity effects, how does your amendment provide more protection against reverse sensitivity?
Well, you can. I mean, reverse sensitivity effects. Yes, I see what you're saying. You're not manage. You need to protect rather than manage. It should. I guess it should be. The clause should be best placed slightly differently. But I mean, the intention is obviously that you do protect them from reverse sensitivity effects.
So
But I guess in terms of adverse effects, if you're managing adverse effects, I think it obviously can include higher types of management in terms of protection, but it's perhaps not an ideal sentence in that sense, but I'd have to rethink it in terms of finding a better way of doing that.
Okay, thank you.
Thank you, Ms Rossa. My question follows on from Commissioner Solomon. So yes, in relating to the phraseology that you've put forward for that strategic direction, my question is in alignment with Commissioner Solomon there, and I note that in paragraph 5.4, the very first sentence of your evidence says reverse sensitivity with respect to landfills is suitably managed by making sure that incompatible land uses are not located in close proximity. So my observation is similar in that, what you've put forward is that there's a bit of a contradiction there, and would be interested in hearing from you in terms of how that might work better in your proposed drafting.
Yeah, well, I'm not sure if I could do it on the spot, but
no, that's fine. Yeah.
I certainly do consider that the higher order policies, like I suppose for you would have heard from Frontiera yesterday, I'm sure as well, that they help give direction in terms of future plan changes that you might get to intensify certain areas or develop new areas, and therefore the incompatible uses in relation to landfills would be, I guess, increased intensification of the residential area surrounding, or allowing certain non-industrial uses into the neighbouring area. So that's the impetus, but whether or not that can be worded better, I would have to go away and think about that.
That's fine. Thank you.
Ms Rossa, my questions really relate to understanding why you need to go down the path of defining this existing land use as being infrastructure or some category of infrastructure, doesn't the industrial zoning provide the protection that you would require to enable the operation of the landfill and its associated activities?
No, I don't think the industrial zone is quite robust enough in that sense. It does have some uses which can provide more sensitive users closer by, or just I mean, for example, the sort of things which we have issues are elsewhere. For example, there's a transfer station in Auckland that has a large Mitre 10, I believe, next door, with a cafe in its garden centre, which is and therefore, you know, when there are occasional odour issues, that those people visiting the garden centre cafe complain. So those are the, I guess, the issues we're dealing with elsewhere, but it's coming through from the infrastructure strategy, the New Zealand infrastructure strategy and the New Zealand waste strategy, that I do believe we need to start thinking of these large regional waste facilities as infrastructure. Mostly because to get a high quality landfill established and operating is an extremely difficult thing from a resource consenting point of view. I'm sure you would have all had heard about Dome Valley, for example, but not only that, it's to protect current operations so that future, because they all need regional discharge applications to be renewed on a periodic basis, and those also are very difficult to obtain if encroachment has made it problematic for the landfills. And I mean, there are generally, I guess, ways of operating landfills where you can have as least odour as possible, but there's always going to be a little bit of odour, and in terms of if things go wrong, or and the types of mitigations become more and more expensive. So for councils operating this facility, I do believe that to maintain the highest level of mitigation is difficult to maintain its, I guess, the cost basis for keeping that odour to the lowest minimum level possible if there's extreme encroachment around it. So it's looking to the future and making sure that these types of facilities have some legal standing in the district plan.
And is this a current issue or potentially a future issue for Timaru District, or is this part of a wider strategy being adopted by your organisation to ensure some consistency nationwide?
This is a wider strategy nationwide. It's not just EnviroNZ. There's certainly it's. I think the whole waste industry is looking for this, and certainly the infrastructure strategy and the waste strategy recognise it as a problem. And they're looking to ensure that district plans do better account for the waste management infrastructure.
And would it be, it may be that we don't agree with you in terms of trying to adapt the definitions or policies around infrastructure to suit this particular activity at this time, and we haven't decided that. But if that was where we land, are there other alternatives that you would suggest that would better ensure the protection of this facility in this district within the current zoning framework?
If there, I guess ideally, and I'm not saying that this is possible in this framework at the present, maybe not even in the future, but ideally you would have some sort of buffer around the landfill. There are some district plans that do have these, and therefore within that buffer, it's an overlay. It would be an overlay in the district plan that certain activities require consent. So, and these would be obviously of certain sensitive nature or high traffic activities that bring in lots of public into that particular facility. So that's the ideal way of dealing with it. If you don't afford it this infrastructure status that I think it should have.
Right. And is the designation another tool to address that, to extend the designation to effectively internalise the buffer around the site? Is that another alternative?
I believe it is, but it would be very difficult to achieve in this location.
Okay, thank you. I have no other questions. Thank you very much for your presentation. Thank you. Can you hear us? Sorry, we've lost the sound. Thank you very much. Yeah, I can hear you now. Thank you. Slight delay in the time. Thank you for your submission. We have no further questions for you.
Thank you.
It's a little bit laggy, isn't it, today? Now we have the Penny Nelson for the Director General of Conservation. We have some issues with the technology.
I think she was just having, I think.
Welcome. We don't quite have a full visual of you on the screen. Do we?
Kana koutou katoa.
There you are. Thank you. Welcome. We're in your hands.
Tēnā koutou katoa, ko Kerry Warnock, ko Kowinua. Good morning, my name is... I'm afraid there's a terrible feedback.
Look,
We'll try again.
just pause. We'll see if we can resolve it. Just a moment. We'll try that again.
Good morning. Can you hear me now? Yes, thank you. Good morning. My name is Kerry Warnock and I represent the Director General of Conservation in these proceedings. The Director General has a statutory function to advocate on behalf of nature, hence the submissions made in respect of the proposed Timaru District Plan. Before I address my legal submissions very briefly, I would take this opportunity to introduce the team from the Department of Conservation, who will play a role throughout the hearings as we go forward. In Ōtepoti Dunedin with me is Elizabeth Williams, who will provide expert planning evidence to the panel, and you'll hear from Ms Williams today and throughout the hearing. A little further north and nearer to the commissioners is Richard Clayton in the Christchurch office, and Richard is a terrestrial ecologist. And then this morning, sitting in the capital, is Alice McCubbin-Howell, who is also in the DOC legal team and will present legal submissions on part of the Director General as we go throughout the hearings. As we progress through the hearings, I should say that our scientific expertise will be supplemented as required in an effort to assist the panel. To make 2 points at the outset. Firstly, I wholeheartedly agree with the excellent legal submissions from Ms Vella yesterday on behalf of the Council. And secondly, in general, the proposed plan is a thorough and well-written document. The Director General agrees with the intent and most of the provisions in the plan, and her involvement is to refine the details for clarity and purpose, particularly to ensure the overall maintenance of Indigenous biodiversity and, of course, the protection of significant Indigenous biodiversity in accordance with Section 6C of the Resource Management Act. Turning to my legal submissions, I understand that the panel has had an opportunity to consider these in advance, so I do not intend to take you through them, save for touching upon 3 points. First is to apologise. There is a typographical error in relation to paragraph 4, Roman numerals 7. That paragraph should read, the plan must also give effect to the Canterbury Regional Policy Statement that contains a comprehensive cascade of objectives and policies, including the foundational objective 9.2.1. Again, apologies for that error. The second point is to draw your attention to paragraph 4, Roman numerals 11, where I explain that district plan objectives are intended to be aspirational. And I quote there from an Environment Court case that states an objective in a planning document sets out an end state of affairs to which the drafters of the document aspire. And I draw attention to the panel's, I draw the panel's attention to that paragraph in relation to the discussion that was had between the submitters and the commissioners yesterday in relation to at what level the strategic direction objectives are set. And it's quite clear from the national planning standards that they are set at the strategic level, the higher level, i.e. at the district-wide level. And as a consequence, in my submission, it is perhaps inappropriate to single out specific sites and or named individuals in the strategic direction objectives, unless there is a very clear inconsistency that needs to be resolved. And it's my understanding that the submitters, particularly Transpower, are not making that argument. And then the third point, before I finish, is to note that I do make one substantive point in my submissions, which is to support the amended wording in relation to strategic direction 02 as provided by the section 42A report writer. Thank you. I'm very happy to take questions on any of the legal tests that I put in those legal submissions before I call Richard Clayton to give evidence.
No questions on the legal, thank you. We'd like to receive your evidence, thank you.
Thank you. Thank you. Then I'll call Richard Clayton to give evidence. You'll see that Mr. Clayton has provided you with a brief speaking notes that he will take you through that summarises his core evidence.
Kia ora Kerry and kia ora to the panel. So ko Richard Clayton takuinga. So my expertise is as a terrestrial ecologist. I've spent 25 years studying and practicing conservation management in New Zealand. Most of my experience has been applied in the backcountry, but increasingly involved with front country conservation. In the Timaru district, this overlaps quite strongly with braided rivers, many of the limestone outcrops and ecosystems, and numerous uncommon ecosystems associated with coastal and dryland parts of the district. I've taken many surveys throughout New Zealand assessing the ecological significance of sites and have some experience managing threatened plants both on and off public conservation land. So the focus of my evidence is that I support the strategic direction 02 of the proposed Timaru district plan, being to achieve at least no overall loss of Indigenous biodiversity by providing some ecological context to justify the direction. So many of the remnant Indigenous ecosystems and species that do remain in the Timaru district are threatened or vulnerable as a direct result of the historic widespread vegetation clearance. And they're also compromised in their functioning from introduced plant and animal species. So we have a lot of formal protection of many large areas, particularly forests and common ecosystems, and have achieved a degree of security through protection for most of the montane ecosystems and all of the important Indigenous flora and fauna that are there. However, much of the Indigenous, there is still a lot of clearance occurring in the low altitudes of the front country landscapes, and this has often been coupled with development and intensification in the sort of semi-natural landscapes that surround natural features. So examples of the former and just increasing amounts of forestry, cropping and subdivision, and of the latter, just an intensification of farming processes such as irrigation, amounts of nutrients and pesticide application, and homogenization of the crops. There's additional pressure on the species and ecosystems from introduced browsing animals and predators, invasive plant species, which in some cases, for example, wilding pines are increasing. We also have new pressures being a warming climate and associated severe weather events, which exacerbate most, if not all, of the aforementioned pressures that we do have. So combined, these negative effects are disproportionately felt higher around the coastal wetland, dryland and river margins, which in turn are the very sites where many uncommon ecosystems and most of the threatened plant species exist. Some good examples of these are the remaining wetlands, particularly around coastlines, braided river margins such as in the Rangitata and the Parirora, or the many limestone outcrops associated with the low hill country in the district, such as at Te Ana Awai, and any of the remaining moraine and alluvial outwash plains. some plant species that live in these environments. So the Pareora azarella and gentians, which are often distributed throughout those small limestone outcrops. There's multiple little genera and species that are highly vulnerable and have recently, in our own internal processing, been given an ignoble status of being on the brink of extinction. So I'll provide some more detailed evidence during the eco chapter hearing. But finally, I just wanted to place some particular emphasis on the need to continue the program of survey work already undertaken by the Timaru District Council, which helps to identify the important status and trend of all remaining biodiversity using the appropriate criteria and a small suite of appropriately qualified ecologists. And in my opinion, the Timaru District have undertaken this work perhaps more judiciously than any other council in the South Island and should be commended on the results of this exercise, but strongly encouraged to continue with the program, which is both unfinished and requires ongoing effort. One of the reasons, the main reason, is that these data are crucial to informing any future decisions around our ability to measure change in status and trend of all existing biodiversity and ultimately achieving at least no net loss. So I'm happy to take any questions too, and also we'll look forward to presenting more evidence with my colleagues actually at a later date.
Yes, good morning. I've just got a couple of questions. The first one, just for my curiosity, what is a kettle hole?
Yeah, kettle holes are post-glacial features, often where a large boulder has been transported by a glacier into a flat landscape or an enormous piece of remaining ice. And the effect of the gravity of that item has left a huge hole in the ground. So often, essentially, because it's a flat landscape, you have a wetland which is bound in all directions and often isolated from other hydrological processes. So they often dry out during dry summer months and fill up during the wetter winters, not always. And they are often the places where we have very unusual species, ones which can cope with a high degree of stress and annual change and extremes in fluctuating hydrology and temperature.
Great. Thanks for that. Because in your paragraph 22, because I've never heard it before, what is your reference material for its mass clearance of ecosystems by Māori and early Polynesians?
So there's multiple references, but probably the safest and easiest is the McGlone papers. So literature that was developed in the 1990s, looking at pollen records during, I guess, the last 5,000 to 10,000 years of New Zealand's sort of biological history. So we can often take a core sample through a wetland and see what was around at certain areas. So that's where we get our estimates for 85 to 90% of the whole terrestrial land environment being forested. And it's reasonably straightforward now to look through a geological or human history and see at what stage we have had less and less amounts of pollen from forest trees in certain areas. So that tracks quite strongly against the arrival of various peoples through various landscapes.
So does that research explain the extent of the clearance?
Yes, it can. The cores they take are assumed to be indicative of the area. So the pollen that arrives in a small kettle hole in the Mackenzie Basin or an associated wetland has only been able to traverse there from a certain, amount of space, depending on what type of pollen it is. So, yeah, I think they can find scale tune within a region and within a district, and probably even to two localities as well. Does that answer the question?
Yes, thank you. And my last question is, what is the difference between no overall net loss and an overall net gain?
I'll probably let my planning colleagues answer that, but for me, I guess I use metrics in terrestrial ecology of species and of the form and function of ecosystems. So I'll probably need to work that out in more detail for my subsequent evidence. But yeah, so the metrics of ecology would be the number of species or subspecies and the status and trend of them, also scaled up across vulnerable ecosystems as well.
Okay, thank you.
No further questions for you. Thank you very much for your evidence, and we look forward to seeing you again later in the process.
Kia ora. Let's flick back to the Dunedin office. Kia ora. My name is Elizabeth, or you can call me Liz Williams, and I'm a RMA planner at Te Papa Atawhai Department of Conservation. Thank you for hearing me today and allowing me to join the hearing remotely. The DG submission sought amendments to a number of definitions and to the strategic direction on the natural and historic environment, SDO2. Overall, my evidence generally supports the Section 42A officer's report recommendations in relation to these submission points. Today, I will cover the points that have been raised at the hearing yesterday, including the definition of conservation activity and strategic direction, SDO2. In addition, I will make some comments on the amendments to SDO2 proposed by Transpower and their evidence. In regard to the definition of conservation activity, my original suggestion for a definition was intended to provide clarity to users of the plan. In my evidence, I accepted the Council Officer's report recommendation and explanation that for this proposed plan, a definition is not required, given the way that the permitted activity rules for conservation activities list what is included. I take the point as further explained at the hearing by Ms. Hollier that conservation activities will be managed by the specific zone rules and therefore will work in combination with the public access provisions. I also understand the point with regards to the wording used in my proposed definition of conservation activity and limit to only Indigenous vegetation and fauna and their habitats. It is noted that within the relevant rules for conservation activities, it provides for land, buildings and structures used for the preservation, protection, restoration of Indigenous species or habitats of Indigenous fauna, as well as other activities such as conservation education, observation or surveying, walking tracks, etc., which may not necessarily be for the purposes of Indigenous vegetation and fauna. Overall, I support the proposal that given the way the permitted activity provisions are set out, a definition is not required for this proposed plan. As noted in Ms. Rachel Poole's planning evidence on behalf of Ngāi Tahu yesterday, I have discussed the proposed amendments to SDO2 with Ms. Poole. I support the amendments Ms. Poole has tabled in her evidence at yesterday's hearing for SDO2. I will now comment on the proposed amendments to the strategic direction proposed in the planning evidence provided by Ms. Ainsley McLeod on behalf of Transpower. I acknowledge that the NPSIB does not apply to the development, operation, maintenance or upgrade of national grid assets and activities or renewable energy generation, and I agree that this is guided instead by the relevant provisions in the RMA National Policy Statement for Electricity Transmission, the New Zealand Coastal Policy Statement and the Canterbury Regional Policy Statement. However, in my opinion, I consider that the addition of the proposed clause X confuses the direction of the strategic direction 02. This sets out the overarching direction at a district-wide level. It does not refer to how the national grid or any other activities are to be managed in regard to effects on Indigenous biodiversity, as this is appropriately dealt with in the more specific objectives and policies set out in the Energy and Infrastructure and Eco chapter. Further, SDO8 sets out the clear direction to enable regionally significant infrastructure, including the national grid, while managing adverse effects appropriately. Again, specific guidance to how this is achieved is set out in the Energy and Infrastructure chapter. That's all I had in terms of my speaking notes, so I'm happy to take any questions.
Thank you.
So I've just got one question, and it's just arisen from the matters you raised in relation to the Transpower submission, and it actually isn't in terms of the detail or the merits of otherwise, but I just wanted to ask your view from a planning perspective about if the strategic directions are set as, you know, proposed and as you put out, do you think there is an available path when you get into the detailed chapters to try and create a carve-out from part of the strategic directions? Or if there is some issues there where the strategic directions don't, where there might be some conflict, we really do need to resolve those now in the strategic direction. So I'm just interested in your view around that.
Yes, I think it can be dealt with in the specific topic chapters. That's where you get into the detail about separating out sort of the regionally significant infrastructure and what the different national policy statements provide guidance for. So you can have policies specific to the national grid within those relevant chapters to deal with the differences in how environmental effects are managed.
Thank you, that's all I had.
And my question, I'm going to put the same question I did to Mr. Clayton to you as the planner for DOC. What is the difference between no overall net loss and an overall net gain?
So no overall net loss. It means no reasonably overall reduction in the type, extent, long-term viability and functioning of Indigenous biodiversity. And when you use it in this policy context, it has regard to the sort of the overall contribution of regulatory and non-regulatory methods. So it's a district-wide sort of level. So that could be things like as well as what comes out of resource consent assessments, etc., and decisions, but also non-regulatory such as local biodiversity strategies and incentives that are offered, etc., for protecting and maintaining Indigenous biodiversity. The overall net gain is a term that's used for biodiversity offsetting. Right. So usually you'll come across that in the more specific policies of the chapter. So it can be things where there are significant effects on Indigenous biodiversity and trying to offset that and create an overall net gain in a different location.
Okay, thank you. Explains it perfectly. Thank you.
Thank you, Ms Williams. Just one question from me with regard to SDO2. So you've mentioned that you accept the way that the SDO2 has been drafted by the processing officer and that you acknowledge that consequential changes to plan provisions within the Eco chapter and other chapters may be required to check alignment further down the track. Mm-hmm. So while I appreciate we're not looking specifically at those chapters now, could you give me a sense of the extent or magnitude of the changes you think may be required further down the track?
I don't think there's a significant changes required. It's kind of refining the policies in the Eco chapter, the objectives and policies in the Eco chapter. so that it aligns with the various national policy statements, including Indigenous biodiversity one.
Okay, thank you very much.
I have no questions for you at this stage. Ms Williams, thank you very much for your evidence. And thank you.
Thank you.
Is that all that you wanted to address with us today? And we'll see you again at a later hearing, no doubt.
Yes, Madam Chair, thank you very much for hearing us today.
Right, that brings us to the end of the first part of the morning session. So we'll take a break for 15 minutes. We'll resume for Forest and Bird. Thank you. Okay, welcome back, and we are now welcoming Forest and Bird to make their submission.
Good morning.
Good morning.
Kia ora. All good
Go
to go?
ahead. Can you hear us okay? I'll turn my microphone off in a minute to avoid the echo, but you start when you're ready. Thank you.
Thank you. Yes, I can hear you loud and clear. Thank you very much. Kia ora, good morning. My name is Nikki Snowink and I'm the Regional Conservation Manager for Forest and Bird for Canterbury and the West Coast. And Forest and Bird is a non-government organisation, and our purpose is to do all we can for the protection and preservation of New Zealand's native species. So thanks very much for the opportunity to present. Forest and Bird made a submission and a further submission on the Timaru District Plan, and it's really great to be here. So Forest and Bird's key interest in the Timaru District Plan review is the ecosystems and biodiversity chapter, and to ensure that the strategic objectives provide the appropriate high-level direction to protect and restore the district's Indigenous biodiversity that is consistent with the national and regional policy. The Timaru District and its land occupiers are often upheld as exemplary for protecting and restoring Indigenous biodiversity through the district's Significant Natural Areas program. It's SNA program. It's really good, as the previous submitter's expert pointed out, and for its careful protection of habitat for species like the nationally critical peka or long-tailed bat, and for the at-risk declining korora or little blue penguin. So Forest and Bird commends the council and the land occupiers of the district on the progress that has been made to date to ensure that Indigenous vegetation and habitat for native species survives and thrives in the Timaru district. However, we also acknowledge that while really good, the district's SNA program is incomplete, and there is still work to do to ensure that it is completed and that the SNAs that have been identified are protected and maintained, and where degraded are restored. The SNAs in the Timaru district are a key characteristic of the district's natural and cultural heritage, and they are also important in providing resilience to the impact of climate change. And we think this should be reflected in the strategic direction objectives. So once again, thanks very much for the opportunity to be heard today. I'm just going to chip through the bits of the Section 42A reports that are relevant to us, starting with the interpretation, then moving on to the strategic direction objectives, and finishing off with the definition that we're interested in. In terms of interpretation, Forest and Bird supports the approach to the strategic direction objectives, and that there's no hierarchy between strategic objectives in this chapter and other chapters and policies of the district plan. And having considered the Section 42A report, we support the officer's recommended amendment at point 2 of the strategic direction interpretation section to clarify that this lack of hierarchy applies with respect to other objectives and policies in the plan. With regard to SDO2, the natural and historic environment, in its original submission, Forest and Bird sought to have SDO2 split into 2 objectives, recognising the importance of natural and historical heritage to the Timaru district's character. This was deemed unnecessary by the Section 42A officer. However, the proposed amendments to SDO2 are supported by Forest and Bird as they strengthen the direction to maintain, protect and restore Indigenous biodiversity, particularly where it is degraded. And a separate clause is proposed to be added to recognise the important contribution of historic heritage to the district's character. And this is supported by Forest and Bird. With regard to SDO3 and climate change, as discussed by the officer, Forest and Bird submissions seeks that provisions provide space for native species to adapt to climate change and to strengthen how the plan will have regard to the emissions reduction plan and the national adaptation plan. The officer explains that it is not clear how ensuring there is room for native species to retreat if necessary could be provided within the district plan, and has suggested buffers to the SNAs. He cautions that this could lock up land that might never be needed, and this is absolutely not Forest and Bird's intention to lock land up. The Section 42A officer suggests that this level of detail is not appropriate in the SD chapter and may be better dealt with at the relevant topic chapters. Forest and Bird accepts that provisions for resilience and adaptation may also fit within the topic chapters. However, the risk is that Indigenous biodiversity is not considered when decisions on climate adaptation and for resilience are made, and vulnerable species and habitats could be lost due to a lack of foresight and planning. This issue is better addressed at the SD level to achieve integrated management. We recommend adding a clause regarding promoting the use of nature-based solutions to SD03. We suggest adding the following new clauses, clause 5 should be SD03, not AD03 there, to broadly give effect to the NPSIB policy 4 that seeks to manage Indigenous biodiversity to promote resilience to the effects of climate change. And there's our proposed words there for a new clause, using nature-based solutions and providing space for the habitat of Indigenous biodiversity to adapt and respond to climate change when considering any of the above clauses 1 to 4. Forest and Bird supports the officer's proposed amendments to clauses 3 and 4. However, with regard to renewable electricity, clause 4 should include inappropriate locations or places. With regard to SD04, natural hazards, as above in SD03, Forest and Bird is concerned that resilience and adaptation for Indigenous species are not adequately considered when addressing natural hazards, and we suggest the following amendments listed there. Natural hazard risks are addressed so that areas subject to natural hazards and risks are identified, including habitat for significant Indigenous flora and fauna. And 2, development is avoided in areas where the risks of natural hazards to people, property and infrastructure are assessed as being unacceptable, including where allowing development would prevent the habitat of Indigenous fauna and flora from adapting or having resilience to climate change. And 3, I think that's as it's written. With regard to, yeah, sorry, go ahead. Is that a question?
No, there's nothing from here, something your end, I think.
Oh, okay, cool. Might have been outside, there's no one else here, so it's just me. With regard to SD01, residential areas and activities, SD07, centres, and SD09, rural areas, in its original submission, Forest and Bird sought to integrate the protection and maintenance of Indigenous biodiversity into the rural area and proposed including another clause to SD09, protecting and maintaining Indigenous biodiversity in rural areas. The officer considers this unnecessary because Indigenous biodiversity is addressed in SD02. Forest and Bird's concern is that the proposed approach separates Indigenous biodiversity protection and maintenance from the management of the environments in which it occurs. And for example, Indigenous biodiversity is not recognised as a characteristic of the rural environment or urban centres. This results in separate objectives which potentially conflict and could lead to ad hoc decision making on matters where there could be greater alignment. This does not achieve integrated management. Protecting and maintaining Indigenous biodiversity is a district-wide matter, and as discussed above, it is and should be recognised as a key characteristic of the district in the rural and the urban/residential areas. However, we accept that the wording Forest and Bird suggested didn't integrate as well as it could have for this objective. So Forest and Bird recommends adding the following clause to SD09, recognising Indigenous biodiversity values as an important part of the character, qualities and amenity values of rural areas. Forest and Bird also considers a similar amendment should be made to SDO1 for residential areas and SDO7 centres for consistency and for integration in those areas too. And we have set out some wording there for 1, 7 and 9. With regard to urban form and development, UFD01 settlement patterns, Forest and Bird has some concerns with the amendments recommended by the officer to UFD01. Forest and Bird's original submission on the UFD, that's the wrong way around, UFD, they should say, strategic objectives sought to retain reduces and add direction to manage adverse effects in SDO1 and to another objective for consistency with the provisions in the plan for how adverse effects were to be avoided, remedied or mitigated, as noted in the officer's report. The officer has recommended accepting Kāinga Order and accepted in part Forest and Bird submission, amending UFD01 clause 3 by replacing reduces with minimises. The officer considers it is not always possible to reduce adverse effects. The original wording would mean considering how new development reduced existing or anticipated effects, whereas the new wording would only require minimising what impact the development may have. This changes the meaning of the clause and is not consistent with Forest and Bird's relief sought. For example, no longer would carbon emissions need to be reduced, they would just be minimised, which may actually mean an increase. Similarly, the change in wording would not prevent an increased adverse effect on the environment. Forest and Bird sought to include and manage, as this is pragmatic even where adverse effects are reduced. They still need to be managed. The objective is about consolidated and integrated settlement pattern. It is not about specific activities. As such, Forest and Bird considers the wording it supports is more appropriate. The officer has also recommended an amendment to UFD01 clause 6 that inappropriately changes the meaning of the clause in our view. Rather than avoiding such areas, the amendment would mean avoiding significant adverse effects on them. This could mean that such areas are not avoided at all and incremental impacts and losses will occur. It would be much clearer to avoid the area in the first place. Again, this objective is about consolidated and integrated settlement pattern. It is not about specific activities. As such, Forest and Bird considers the notified wording is more appropriate and that how or the extent to which adverse effects are to be avoided, remedied or mitigated is addressed by other provisions as sought by Forest and Bird. Forest and Bird accepts that additional wording it sought may not be needed. However, the amendment proposed by the officer to clause 6 does not leave such direction on avoidance of adverse effects to other plan provisions and is not supported by Forest and Bird. We seek that the Commissioners reject the Section 42A officer's recommendation on clause 6, and that is avoiding, striking out significant adverse effects on and just leaves it as avoids areas with important natural, cultural and character values. With regard to definition, I think there was a bit of a discussion about this with the last submitter and I missed yesterday, so I'm not sure where this got to, but our concern is around the Department of Conservation activities. The Section 42 officer has recommended deleting the definition of Department of Conservation activities and considered including a definition for conservation activities. Ultimately, the officer has rejected including such a definition, although consider wording similar to that proposed by the Department of Conservation may be appropriate. Forest and Bird submission was in support of the current definition. While we accept the Section 42A officer's reasoning for deleting that definition, we consider that an alternative definition should be included given the number of provisions which provide for conservation activities. However, we are concerned that an alternative definition could provide for a very different scope of activities. In our view, any alternative replacement definition needs to be clearly defined and limited to only those conservation activities where there is certainty as to the appropriateness of the activity. This is because the plan includes directive enabling provisions on this term, conservation activities. The Department of Conservation recommends a definition for conservation activity, which is generally supported by Forest and Bird. However, we consider there may need to be some refinement to the inclusion of things like track construction and maintenance, so that activities under this definition are carried out consistent with provisions for protecting SNAs and for vegetation clearance. And I've listed DOC's, I've put DOC's proposed conservation activity definition in there, which is generally supported. And that is all. Thank you very much for the opportunity to present.
Thank you. I'll see if there are any questions for you. I could start the other end.
Sorry, I think we were all hoping to have more time. Can I take you to your paragraph 21?
Yep.
And I just want to explore with you, your last sentence in that says that Forest and Bird prefers the notified wording, and that's how the extent to which the adverse effects will be avoided, remedied or mitigated is addressed by other provisions. So I understand that. But I do wonder whether your wording would actually enable that. Because when I look at what you want to clause 6, it's avoid areas with important natural character values. And so I'm wondering how even any subsequent provision in a different chapter that might provide for remedying or mitigation would actually be able to work if the strategic direction, the only strategic direction, is to avoid. So I'm just wondering whether there's a wee bit of a contradiction perhaps in what you're intending in your last sentence and with what your wording actually does.
Can I just come back from leave, and I've picked this up from somebody else to present today from our planner. So can I take that question back to her and ask that of her, if there's a contradiction in there, and get back to you?
Yeah, it would be helpful to have an answer on that. So, yep, any way possible was great. Yeah.
Yep. Cool. I'll ask her that.
I want to talk about your request to separate natural and historic environment. Did you realise that that request unintentionally, perhaps unintentionally, meant cultural values were to be separated from natural environment?
What's the question again? I'm kind of not following.
So,
oh yeah.
So at 156.38, you requested for historic and natural environment to be separated into two separate objectives. Did you realise that the cultural environment was perhaps unintentionally caught in that request?
I hadn't really thought that through, I guess. We like the proposed amendments to what the officer has proposed in SCO2, so we are no longer seeking for it to be separated out, because there's a additional clause in there to recognise the historic characteristics specifically.
Okay.
The historic heritage.
Yes.
Yeah.
So you didn't mean to, you weren't intending for that to even though the officer has rejected it and you've accepted his amendments, did you intend to capture the cultural environment in that request?
I don't think so. Yeah, no, that would have been unintended.
Okay. I've just got a couple more questions. Does the Society have concerns that a domestic garden could include shelter bouts, and what is the basis for that concern?
does a domestic garden include shelter belts? I'm not too sure what our position is on that. And what's your question?
Well, I want to know what the basis of your request was to have a definition for domestic garden. And you reference, in your submission, you reference shelter belts.
Yeah, I might have to take that back and ask the planner for that as well.
Okay, all good, thank you.
Cheers, thank you.
Thank you. Can I take you to paragraph 8 of your talking points?
Yep.
I wanted to check your understanding of SDO2. In the last sentence, you have said, and a separate clause is proposed to be added, and that this is supported. Whereas when I look at SDO2 as contained, as appended to the officer's report, an additional word of historic is added, but there's no separate clause being added.
Oh, I may have
Could you just check
misunderstood
that for me, that we've got the same understanding there about the relief that you sought?
I thought there was a new clause about historic heritage to highlight that as a characteristic at the end of that one.
There is an additional word, so
right.
The word historic is added.
Yeah.
But it's not a whole new clause. I just wanted to check that we were on the same page there.
Yeah, no, just to highlight the importance of historic heritage in the area is separate from.
Thank you. And with regard to your concerns around UFD 01 settlement patterns, you've talked through your concerns around the recommended change from reduce to minimise. It might be a question for your planner. I'd just be interested to kind of understand the difference that's been suggested in the outcome. I'm finding it challenging to understand the difference, the point that you're making there. You might be able to tease this out a bit now, or it might be something to do that your planner could do.
Yes, I will ask my planner to explain that better for us. But yeah, my understanding is that, I'll get her to do it, if that's okay.
Thank you.
Yeah.
Lovely, thank you. That's all my questions.
Thanks very much.
I just have a question for you in relation to paragraph 10 of your speaking notes and your proposed amendments to SDO 3 and clause 5. Could you just explain what nature-based solutions are? Is that an accepted term or?
Yeah. Yep. So nature-based solutions are identified throughout the National Adaptation Plan, and they are becoming an alternative to hard engineering solutions. So sort of, for example, instead of building a stop bank to keep the river, you build a wetland. So it's kind of like expanding wetlands, and this is really appropriate or relevant to the Timaru district, especially because it has quite a lot of lovely coastal wetlands. So it's about expanding those wetlands, or expanding dunelands, or expanding kind of the natural sort of infrastructure and to help create climate resilience. And this is a thing that we are supporting throughout New Zealand it's much easier to expand and build on what you've already got rather than, it's been demonstrated again and again that stop banks don't actually work in the long term. So you're better off making space for the nature. The Room for Rivers campaign, I guess, is the classic example of that. Is like, instead of containing the river in a small area, give it back space so it can flood. So, the space has been encroached upon by various activities over the years, and then you get a big rainfall or a climate-related extreme weather event, and it destroys everybody's property. And it was a riverbed or a floodplain to begin with. So it's really about, that's a nature-based solution, is giving the river back its floodplain to avoid damage and destroying people's properties.
Thank you for that clarification. Thank you very much for your presentation today. Forest and Bird will no doubt be back again before the panel in later chapters, so we look forward to your presentation then. And
thank you very much.
Just to follow up the matters that you were going to clarify, if you could do that as soon as possible and just send that through to the hearing administrator,
Will do.
That would be most helpful. Thank you.
Great. Thank you very much. Cheers.
Welcome. We have our next submitter, David Alexander, and... Oh, sorry. My apologies, not quite sure where to look. Perhaps I'll let you introduce yourselves, but you're here to make submissions on behalf of David Alexander and... Thank you.
Just need to put your microphone
on. Should I kick off? Yeah. Kia ora koutou. Good morning on what's a beautiful South Canterbury day. My name is Benjamin Alexander Payne, and I'm here to make a brief statement on behalf of my parents, David and Suzanne Payne, who are here with me. As a form of introduction, I'll then pass over to Lynette Worth, who is acting as our consultant. Lynette will speak on her professional evidence statement related to one aspect of the proposed plan strategic direction relating to rural lifestyle infrastructure. I hold a BSc in Geography and Ecology and a postgraduate diploma in Human Geography at the University of Otago. I also hold a PhD from the University of Otago, which focused on strategic land use management within the South Island's high country. I began my professional career as a resource management consultant with Mitchell Partnerships, which is now Mitchell Daish, and I've worked across a range of complex project assessment of environmental effects, and in particular supported the provision of advice to Auckland Council during the process of amalgamation under the Auckland Unitary Plan. Since then, I've worked on a range of roles in areas of land use planning, complex risk, sustainability, and climate change mitigation at global, national, and local scales. I'm self-employed as a consultant and currently work remotely from my parents' home in Geraldine, supporting them on the property when I'm able. One of my primary clients is currently Auckland Council, so therefore I have a relatively good understanding of the RMA and council processes. I certainly appreciate the challenges of achieving balance across complex interests at a regional district level. I guess I'd like to emphasise that this is not always an easy balance to strike, but it is critical that councils, whether they are large like Auckland or mid-sized like Timaru, show vision for their communities. And I guess this is especially important during a district plan development process, and a lack of vision and poor strategy can effectively stall a small community like Geraldine and undermine its future prosperity. To provide a bit of a snapshot, I guess today I'm not acting in any professional capacity. I'm here on behalf of my parents. The ongoing process of seeking to engage constructively with the Timaru District Council regarding the proposed plan has been lengthy and at times challenging for them as lay people, and the increasing strain is impacting their well-being. We're grateful to now have the opportunity to be heard by the commissioners. You'll be hearing more from us as other matters are covered by district plan hearings, as well as from other submitters with similar issues. In terms of a snapshot of our situation, my parents have grown pipfruit, apples and pears at Peelview Orchard on the northern fringe of Geraldine Township since arriving in August 1995. At the time, nearly 30 years ago, they were full of excitement and anticipation for what the future held as we embarked on a rural life in South Canterbury as a family. They'd recently purchased an established orchard, which, while run down, showed a great deal of development and production potential. They left professional roles in Wellington, packed their lives, including my sister, who was 3 at the time, myself, who was 6, and our Labrador Chansey into the back of our station wagon, and together we moved south to be closer to my grandfather, who lived here in Timaru. Mum and Dad have persisted for 29 seasons, frequently confronting challenges, both weather-related and industry-driven. They have survived by keeping things simple, working incredibly hard, and doing as much of the work as possible themselves, and ultimately growing a very high-quality product. They have also consistently lived a very modest life. The challenges they face now are very different. Mum and Dad now have 9 neighbours on our immediate boundaries. As stated in both our feedback and draft plan and our submission on the proposed plan, our orchard now stands as an island of rural use within an increasingly developed and intensively populated space. It is a small pocket of production and a broader precinct of lifestyle and residential land use, and these residents have very limited understanding of or sympathy for orchard activities, including the use of air blast chemical spraying, frost and hail mitigation, and bird scaring cannons, to name a few. Over time, the context of where we continue to orchard has changed significantly, both in terms of the physical context of the area, but also the social expectations placed on us and on horticultural production. The reverse sensitivity impacts of adjacent residential and rural lifestyle development on our boundaries have increasingly made it unachievable to produce at the scale and intensity required to be viable as a pit fruit producers on what is a small property. The total area of the property is about 8.8 hectares, and it is the largest lot within this precinct. But the production area in apples and pears has now been reduced to only 1.5 hectares to maintain our social licence to operate. The balance is used for seasonal baleage and sheep grazing. The district plan process is therefore important for a pathway forward it hopefully provides for my parents' future and for our family. The proposed plan zones 56.134 hectares area north of Geraldine, defined by Main North Road, Templar Street and Bennett Road for general rural use zone, with a future development area FDA 11 overlay beyond 10 years for rural lifestyle. Peelview Orchard is within this area. Our submission is that the area should be zoned rural lifestyle zone now to reflect its existing predominant use, bearing in mind that the 56 hectares between the 3 roads is already subdivided into 38 titled lots. Hence our interest in the strategic directions of rural lifestyle development. The development of the current proposed plan has been a long process. The initial scoping for the plan review was undertaken in 2015. This included reviewing the operative plan and previous operative plans. The scoping identified that weaknesses in those plans had allowed inappropriate rural lifestyle development to occur, and the clear intention of this proposed plan is to not allow this to continue. This is well covered in the document, Topic 13, Rural Residential Areas Discussion Document from December 2016, 2.0 Issue Identification. A pertinent quote is in this report states, "Such lifestyle development has historically occurred on an ad hoc basis, resulting in poppy seed development throughout the district's rural zones." My parents' reality, though, is that the consequences of these prior weaknesses have had significant impacts on their business's viability. They know that there are no further pivots that the business can make, which is a daunting prospect to confront at their age and stage, given their inability to retire after 3 decades of hard slog on our property. District plans, I'd like to emphasise that district plans and council processes are more than just esoteric concepts and the rejig of lines on planning maps. They can and do have profound impacts on residents, financially, socially, and their health and well-being, as with our situation. We have taken every opportunity, both formally and informally, to engage constructively and positively with the Timaru District Council to explain the challenges we face operating a now very small horticultural operation on our property. We welcome the fresh set of eyes and ears that the Commissioners will provide to this process and the opportunity to address these matters more fully in later hearings. Going forward, we would also invite the Commissioners to our property so you can see for yourselves the challenges we continue to face, but also the opportunities the northern end of Geraldine offers in terms of meeting issues with deepening housing unavailability in our community, a matter that other Geraldine residents have raised in their submissions and an issue we share with other communities across the district. Thank you for listening today, and if you have any questions, we will do our best to answer them for you. However, at this point, I'll hand over to Lynette, who will address the proposed plans to strategic directions specifically.
Thank you. Would you prefer we go straight to the planning evidence and perhaps then come back and ask some questions?
That's fine by me, then you might have a holistic overview.
Let's do that and then we'll come back. Thank you very much.
Thank you. Can you hear me okay?
I can.
Yeah, you can hear me? Okay, right. Thank you for the ability to speak to the hearing today. My evidence is very short and specific, so I haven't provided a written summary. There's a summary in the front of the evidence that basically covers it. But just by way of comment, it's important that strategic directions are at the overarching level. And my evidence focuses totally on about a dozen words and one strategic objective about the residential areas and activities and the stipulation that infrastructure in rural lifestyles should be reticulated. And I've set out in my evidence a number of reasons why I don't consider that requirement is appropriate. I listened in yesterday and I heard Mr. Willis's commentary and questions from the hearing panel, so I'll just make a couple of comments on those. I was very interested in the criteria that Mr. Willis set out, which informed the strategic directions, and I've gone back and looked and said, well, which of those criteria informed SD 01 2, and I'm not really quite sure, but I did find in the growth management strategy F71 for rural growth, the principle was that rural residential was to be attached to existing settlements, limited and integrated with infrastructure as per the Canterbury Regional Policy Statement. And my evidence and Mr. Willis's evidence actually addresses the Canterbury Regional Policy Statement, Policy 5.3.5. So my view is that what's now in the strategic direction goes beyond that growth management principle that could be the reason that's informed the inclusion in the strategic directions. The other issue was yesterday a question about, can a plan be more stringent? Yes, a plan can be more stringent than a regional plan, but to be more stringent, it needs a very robust 32 report to justify that approach. And to date, I haven't seen any evidence to support such an approach. And therefore, in my view, consistency should be achieved in the absence of such evidence. I think the other thing that is important in terms of going forward for rural lifestyle is that there is the ability for innovation. And actually Ben Payne was actually at a conference the other day where new systems for sewerage management were outlined, and you know there's new technology all the time, and therefore I think we need to be sure that we're not foreclosing on innovation and new technology by stipulating a certain requirement in the plan. And I actually see within the regional policy statement and the regional plan that there is ability to recognise such an innovation. One comment Mr. Willis made yesterday was that he could perhaps be more precise with the direction in this particular subclause. I suppose my view is that I think it should be left that a bit more open so that there are options for future development. And the recommendation in my evidence is just by deleting the word reticulated, you achieve a coordinated pattern of development capable of efficiently connected to sewer and water infrastructure, means that the opportunity to use new technologies still remains without a requirement to be reticulated. So that's a summary of my evidence, and interested to take any questions.
Thank you very much for that. I'll check in with the panel, and just for the panel's benefit, if you would like to ask a question of the submitter directly, please take the opportunity to do so and or address the expert evidence. Thank you.
Okay, good morning. My question is for the planner, and I do just want to preference it by saying that this question is quite a technical one around some of the wording you've used in your evidence. It has nothing to do with the merits or otherwise of what you're seeking. So just to preface that, I'd like to take you to paragraph 528.
Yes.
And sorry, you've got there before me. Okay. And it's around, and it comes up in your summary, because the statements you've made in your summary, like right at the start, were quite strong in terms of inconsistent with the regional plan, doesn't give effect to a regional policy statement. So it's that aspect I just want to explore with you a little bit. And so what I just wanted to test around, in terms of the plan not being inconsistent with, and you reaching your conclusion that the having the word reticulated is inconsistent with the regional plan. That was what was in your executive summary, effectively. I just want to test with you whether that actually is inconsistent with it, or whether for different functions, I certainly get your view if the District Council was seeking to control the discharge, because that's a regional council function. In this situation, merits or otherwise, what they're looking at is requiring the way of providing the infrastructure. And I just wonder if on reflection, are you still certain that that actually is inconsistent with the regional plan? And could you just help me understand it a little more?
Well, it was interesting yesterday that Mr. Willis actually raised a question about, well, what does reticulated actually mean? And my interpretation was that reticulated mean joining into a network. Now, without a clarity around that word reticulated, that it's probably difficult to say, well, what exactly is consistent or not? Because if it means joining into a reticulated network, then that, I believe, goes beyond the regional plan. But maybe the area of clarity that needs to be sought is around the use of that word reticulated.
So when you say it's inconsistent with the regional plan, is that because it contradicts, which part of the regional plan is it that you're looking at? Is it, I mean, I understand the rule, so are you saying it's inconsistent with the rule providing for on-site supply, or is it an objective or policy or somewhere in the regional plan?
Yeah. I put in there the rule 5.8 in the regional plan provides for on-site wastewater systems.
Yes.
So, and so I saw that provision in the regional plan, which doesn't require connection to a reticulated system, was where I saw the inconsistency.
Right. Okay, thank you for that clarification.
Could I touch on that as well?
Sure.
I think the kind of issue we have as well is that surrounding us we have places like Woodbury, Peel Forest that will never be kind of attached to a reticulated sort of community-held controlled system. And if we look at places like Jack's Point or Tara Iti, using what Lynette was touching on with, say, inner flow systems, Jack's Point is not council controlled necessarily, but it is a very effective system for managing effluent from 750 houses. So I think there's a level of needing to iron out kind of what's an effective, best purpose system versus where the kind of line of council control fits with that.
Great, thank you. And then my last point, it's similar to the last one, and
yes,
but this one relates to the regional policy statement, and I think it's section 1. I think it's your section 1.4a, which actually is your introduction, which is, oh, hang on, yeah, 1.4a. So the fact that it does not give effect to the regional policy statement, is that due to the fact, I just want to be clear as to the why it doesn't give it, because my understanding, I think, is in terms of what it doesn't give effect to means it's like heading in an entirely different direction than. So
right.
I just wanted to test with you that there's something different other than the fact that, in a district context, you can do things different to what the regional policy statement leads, and that's not necessarily inconsistent with. So I just want to be very clear about where you see the
not giving effect to.
Not giving effect to versus shouldn't do it. I think that's what I want to understand.
So if you go to my 5.20, I refer there to the policy 5.3.5 in the RPS, and Mr. Willis also referred to that in his evidence, and that sets out about the type of system ensure development is appropriately and efficiently served for the collection, treatment, disposal, reuse of sewage and stormwater, and it sets out some principles. But what that policy does not do is stipulate that it must be connected to a reticulated supply. It wants an appropriate and efficient system, and I believe that the district plan should also be taking that approach, that you want appropriate and efficient systems for disposal of effluent and stormwater.
Right, but so you see the fact that the current, let's say as it currently stands, the provision requiring reticulation isn't the district council just expressing a different view on what it considers to be appropriately designed, built, managed, upgraded and maximised services. You see it as being absolutely not giving effect to. I just want to be very clear on that.
Yes, I do, and especially it comes back to that issue that's been raised. Well, what do they mean by reticulation?
Right. Okay, thank you.
Yeah. Talking about reticulation, given that I want to put a scenario to you. Given the introduction of the NPUD, it's not too hard to imagine that in time infill could occur on the rural lifestyle blocks to say 12 houses per hectare or even 15 or 20 houses per hectare, given I think that a lot of systems require land, wastewater systems require a particular area of land. Could you imagine a council reticulated system would be more practical than an on-site treatment in that situation?
Well, if it was going to be developed into urban and rezoned residential, you've got a completely different situation than if it's rural lifestyle. So I would expect if it was going to go into fully zoned residential, you would want to have a reticulated supply, but what we're talking here is about rural lifestyle development.
Okay.
I could probably touch on that. I think the situation that we live in is also a prime example of that, where the area is retained general rural, but up Main North Road on both sides you have intensive residential sections, all of which are on septic tanks. So last year, there's an 85-year-old woman who has had a failing septic tank. There is tension between ECAN and District Council on what the solution is. So she's high and dry, and every time the water level rises around her property, it causes problems for her and her neighbours. So what I think we've seen is an intensification of the area around us without strategic service. We have a number of properties coming up in the last 5 years. All of those are on septic tanks. So regardless of what the solution is, it needs to be future-proofed.
So in your research, or in your, was it a conference that you went to about, did they have wastewater systems effective wastewater systems that don't require a lot of land?
Yeah, the one, so Innerflow, I should have bought the leaflet, but I had a good conversation with the guy. And the Jacks Point one is a particularly interesting example for a very large-scale development. But, when we look at, those systems can be designed for one house or 1,000 houses. You have an outfall plane into a forestry area or that sort of thing. But my understanding is that the level of treatment is incredibly high, to the point that it is, not a significant risk to be releasing some discharged land.
Because I too have got some experience with on-site treatment systems. So, yeah, thank you. Thanks for that.
Pleasure. Sorry. I just wanted to reiterate, Mum just said, the most recent development on Main North Road is 1,000 square metres with 2 units, two-bedroom units, and it's a dispersal field. So, yeah, I think there is complexity in our area that maybe you could come and explore a little bit further.
Yes, so I do have a question, but before I ask, I just want to acknowledge, Dr. Payne, that sometimes you're put into these positions where you represent your family, and I've been in this position myself as a lawyer, where it just is different. When you're caring for your whānau, it just is different. And I wanted to acknowledge all of the information that you've shared and the comments that you've shared. Really helpful and really influential, and you can walk away knowing you've represented your whānau well. So I wanted to start from that point. And my question is actually about Jacks Point and understanding the difference between Jacks Point and the area that we are talking about here, and what that system looks like, and why that's a really relevant analogy for you to use, if you know it well.
Yeah, I'm not arguing that, Geraldine should become a Wanaka or a Queenstown and have all this highly intensive development on our doorstep. What I'm saying is that, especially within a district plan, there needs to be scope for innovative solutions. So even when we look at setting a minimum size limit of, say, 2 hectares for rural lifestyle, it's sort of a nebulous, arbitrary amount of land based on this sort of idea of a pre-existing kind of treatment option technology. But in actual fact, it could have perverse outcomes because it's going to be wasteful, potentially, of a very limited rural lifestyle land resource. So I think at this place in the sort of district plan process, we need to be open to being innovative about how we look at wastewater management. We want to achieve the best practical outcome without setting really rigid, unreachable rules that will start. And I'm not saying that other higher level developers might not try to corrupt that system. I fully understand that there's pressures and there's tensions in that space, but I think it's about enabling council's discretion to achieve the best outcome for a given area of land, rather than setting in stone a really sort of rigid framework that is impossible to work to and doesn't empower that discretion. It's an AEE matter, right? When you come to council with a development proposal, you submit the assessment of environmental effects. It is on the power of the council and their research and intuition and knowledge of the local area to make an appropriate call on what's going to be effective.
Thank you, Dr. Payne and Mr. and Mrs. Payne. Just to echo my fellow Commissioner, I really appreciated your submission today. It's very clear, very comprehensive, and understand the importance of the issues that you've raised for your family. I did wonder, Madam Chair, whether now or at some point in the hearing process, I personally would enjoy being able to have you point out your property and the surrounding land uses and being able to see those overlays. And sure. I'm not sure if that's possible today, but it could be useful if it was possible now.
I don't know if I have maps that we've done in GIS that I could share with you guys, but we were going to have that at the zoning hearing in July and then FDA. But
definitely will be very useful to have it in that context as well. But if it would assist today, I think, to just get a sense, because I was going to have some questions about, you know, what's happening around the property, and it may be just more efficient if we can get a visual. So,
of course.
You might want, you can go back.
Ben, have you got your PowerPoint, or do you want me to? I can email it.
Can you share the PowerPoint, Lynette?
I don't know if I can share it, but I may be able to email it.
I'll bring the PowerPoint. I'll flick it.
Look, there's no rush, so let's just see if we can do the best we can and get it up there. So take your time. Thanks.
Yeah, I can speak to that as well. So
a decision was made late in the day that we would not use this particular method. So.
Sorry.
That's Lynette.
I'm just trying to find it.
So this is our property here, 8.8 hectares. Provide some context. We did own one as well. That was our fruit salad block. It goes back to 1995 when we arrived. So there was a block under this neighbour. Our neighbour came and approached us. And the wisdom we gave mum and dad at the time was subdivide as much as you can. They were all full of anticipation and excitement. Only watching and endured in, so they continued on, and I guess maybe we should have followed his wisdom. In 2006,
about a year old, so we made the decision that we still had this block here that we could develop and that we could continue developing that block. So in 1996, I think, we lifted about 5,000 three-year-old trees and we transplanted them into this block. And cost of the trees, everything else, and we got those trees into fairly rapid production as an export-focused orchard. There were 10,000 trees in this block. Can you remember what year then? Our neighbours came, I think in 2006. They were also orcharding in this block here, and this block right through here was also theirs, and they had another block over here, which is where we sourced the trees, the 3-year-old trees that we planted. They came and sought our permission to subdivide the block they had there into 2. And I mean, it was ridiculous. Wouldn't have worked for us to not give them permission to do that, because whether it was one house here or 2 houses here, the outcome for us was going to be the same. It was going to mean increasing, reverse sensitivity effects. There is a shelter belt there, but it's on their side, not on ours, so they had effective control of the shelter belt. And we didn't know how sort of close they would go to the boundary or anything else. So we didn't deny the permission to do that title change or split, and quite rapidly thereafter, these houses were under construction. We started by removing the first rows of trees. You can almost see on this those were, and we removed quite a number of the trees, tree rows, and just sort of slipped it back. But at that stage, you start to lose your economies of scale for export. Export is quite a risk. There's all sorts of issues around it. But if you're not producing enough, it's done on a carton basis. So if you're not putting enough cartons out there to cover the costs of your Europe gaps and your BRCC, with your British retail standards and all of those sorts of things, when you've got currency fluctuations and weather and all the rest of it, it's really, really difficult. So at that point, we retired the 10,000. So we've only just run out of firewood from that.
And there was only 4 years of production from that
about
block.
4 years. By 2010, all of those trees were gone. At that point, we did a bit of a mixed model, because we had all the home blocks still. It was all intensively farmed. And at that point, we were just sort of sending some for export and through another party and building up local market measures for ourselves. And basically, over time, we just consolidated around that local market presence. Our point of difference is peers, so all of us down here is the rest is. But apples now are a moving thing, really.
I think we should cut to chase and just touch on that subdivision. So we subdivided this block off, and because basically we received that health authority complaint, so we retired that block of land and we intensified our interest to the south. The subdivision was an immensely challenging process. We got taken to hearing by a working group over the fact that Rapapapa stream runs through here, and they wanted a 5-metre easement on each side of the creek right up. We only control about 300 metres of that creek through this bit here. So given the cost of that, the decision was made to sell that. So as you can see, we've gone from a large property and we've just condensed down to basically a situation where we're sitting on land that the kind of context is set around us, but if it's retained as general rural zone, we can't move. So yeah, it's a really sticky situation given that there's, like, for example, if we go to Harper's down here, 80, so that's already 6 titles that all can, 5 titles that all can be built on. There's various other titles in here, so
these are all titled hills, so they just can't. In this stage, as is this, they just get squeezed. So there's 38 titles altogether, but only 28 of them want to go.
Right.
There's still potential for another 10.
Thank you. That's been really, really helpful in the context of this hearing, and we will obviously hear more further down the track. But I'll just circle back to you, Commissioner. Was there anything else?
I was interested in seeing the planning overlay but that's possibly, that can wait maybe till later in the, and I can always look myself online. The proposed plan, the proposed. Yes, so we can do that in our own time, and maybe next time we can have a closer look. Yep. Yep, great, thank you.
And the only question follow-up question I had for you is the extent to which you may have engaged with the council around the future zoning of the area leading up to this process.
Yeah, for sure. So we have kept across it at every step of the way. What would you say? So we submitted on the draft plan. We were heartened by that because it showed rural lifestyle coming up to our western boundary. So in the submissions we made to that, we were like, great, but actually that zone should reflect the use of the wider area on the basis that Bennett Road and Templar Street actually provide a cohesive buffer between the rural and the urban to the south. That's why we were pretty just blown away when the proposed plan came out and they'd removed all reference to rural lifestyle and just slapped a future development area plus 10 years blocking any further subdivision in that area for beyond 10 years. Our kind of frustration around that was basically it picked winners and losers, you know, so anyone that had got their titles through early were fine, home and hosed. Other people have no flexibility, especially given that the area is already a development area, right? And also we'd been engaged on the draft plan, but then it changed so immensely that it was like, well, what were we actually engaged on? You know, like, well, there was no feedback that said, oh no, this should be a future development area. This was just sort of like a knee-jerk sort of thing. Yeah, and I think we were sort of informed by the plans documents from 2016, which sort of clearly showed that, you know, it validated and reinforced the issues we were facing around poppy seed development and that sort of thing. And it said that it should all be RLZ, yes. We emailed David Burrell, Hamish Burrell, sorry, to seek his understanding and clarification. He visited the property with our community board. Yeah, we've had fairly vague kind of interaction, but not much. Then earlier this year, we didn't really feel like we'd had a lot of reach. We had no traction with council at all, really. So basically, we were talking to our community board rep, and I saw our councillor, Gavin Oliver, and basically we emailed Nigel Bowen to come and speak with us. And it was very clear to him the sort of pressures and actually significant amount of strain that Mum and Dad were under. Through that meeting, my dad burst into tears, which I lost track of my words. It was pretty hard to engage through that. But yeah, we have tried to be active and constructive. My frustration with this process, I guess, is if you don't have a huge amount of money to throw at a consultant or have a legal team, you know, there's a risk you won't get heard. So actually investing in a consultant is quite big for Mum and Dad. You know, it's not an insignificant cost to take on.
Thank you very much. Time to present today, and I certainly also echo the sentiment from my fellow commissioners. Yeah, it's been a great presentation, help us to understand the context, probably highlights a number of issues across the district where other townships may face similar circumstances. So we will see you when you return in the more zone-specific hearings, but thank you for taking your time.
You might get a slightly more refined region
Oh,
that
that's
walkthrough. But yeah,
Um,
thanks for your humility. We really appreciate it.
No, it's fine. And thank you very much for the planning evidence as well. That's been most helpful.
Thank you.
And our final submitter of the day, Transpower New Zealand. It's not on my list. This is what was in front of us this morning. I forgot. Not our final submitter, I'm told. We still have groundswell, thank you. But welcome, Transpower. When you're ready.
Oh, thank you. Good afternoon, panel. Thank you for the opportunity to speak to Transpower's submission today. I'm Sarah Shand, an environmental planner in the Environment Group at Transpower. Here with me today is Miss Ainsley McLeod, who's prepared our expert planning submission. The main purpose of Transpower's appearance today is to introduce ourselves to the panel early on, as you'll be seeing from us again through the hearing process. We thought, if it's okay with the panel, that I'll briefly speak to the company evidence I prepared before handing over to Ms McLeod to speak to Transpower's planning evidence. And then we can take any questions at the end.
Thank you.
I acknowledge that the panel has read my submission and will take the opportunity now to highlight my key points. Transpower New Zealand Limited owns and operates the national grid, which transmits high voltage electricity throughout New Zealand from major centres of generation to major load centres such as our towns and cities, and directly to large load customers such as Tiwai Point aluminium smelter. Transpower is essentially the electricity equivalent to the state highway network, transporting electricity around the country. Transpower also has the role of system operator, managing real-time information about electricity use and generation to balance demand and supply on our national grid network. Within the Timaru district, there are 9 transmission lines and 2 designated substations. Transpower also has designations for 2 new substations which are yet to be constructed. Transpower has active projects in the district concerning both existing substations, as well as carrying out its usual maintenance and upgrade works on its transmission line assets. Transpower is also aware of a number of what we call customer connection projects within the district, which are at early concept or investigation stage, which may require associated work on the national grid. As outlined in my evidence, Transpower recognises the critical role that the national grid has in helping Aotearoa New Zealand's journey towards achieving a net zero carbon emissions by 2050. Through a series of strategic publications that Transpower has produced since 2016, Transpower has been sharing its views on this new period of electrification growth and how it will plan for the development of the transmission system of the future. Our electricity system is already around 85% renewable, and this is set to increase at pace over the coming years. There will be an enduring role for the national grid in the future, and the need to build new national grid lines and substations to connect new renewable generation to sources, connect new renewable generation sources to the electricity network. Thank you. I'll now hand over to Ms McLeod.
Thank you for your time today. By way of sort of introduction to the evidence you'll hear with me over the course of the hearing, in addressing the relief sought by Transpower, you often hear from me that the district plan needs to give effect to the national policy statement on electricity transmission. You'll hear it from me time and time again. This NPS recognises the national importance of the national grid and the particular challenges faced by the national grid in an RMA context. As such,
The MPS has the effect of setting the national grid apart from other assets and activities and means that there will be situations where the district plan similarly needs to set the national grid apart. And that may be by including bespoke provisions that are specific to the national grid. That said, there'll also be situations where generic provisions do the job in giving effect to the and there'll be circumstances where in order to give effect, the bespoke provisions will need to come in. My task over the coming months in assisting you will be to provide my opinion about where this should occur or where the generic will be more than enough to equally give effect to the MPS. I note that bespoke provision approach has been taken in the RPS with policy 16 for capturing the key elements of the MPS, and in the association method, there's guidance to what the district plan must do. Turning to my evidence for hearing A, I think I can be very brief. I only have a small number of matters to cover and I only had a few matters left in my evidence. You'll note at page 5 of my evidence, table 1 sets out the large amount of agreement I have with the section 42A authors, so I don't intend to address any of those matters today. The first element in my evidence that I do address is the use of the term national grid versus electricity transmission network. Now, this is just a matter of a term. They are both the same thing. But my evidence expresses a strong preference for the use of the term national grid throughout the district plan. In my view, national grid provides greater clarity for plan users and does not give rise to misinterpretation. It better aligns with the provisions throughout the district plan, for instance, like the rules that apply to the national grid yard. If I can explain the reason for my preference a little more, in my experience, where plans have used electricity transmission network, plan users often confuse Transpower's assets with those of other electricity line owners. For instance, people often think if it's a lattice tower, it's national grid. If it's a pole, it's a distribution line, and it's just not that simple. And in fact, in Timaru, there are examples of pie poles where there's the 2 wooden poles and lines on those. They're the national grid, but other people wouldn't understand that so much. So I think it's just clearer to say national grid so that there's no confusion about what provisions apply to what. Now, the Section 42A report says this probably actually resolves when we come to look at the definition of regionally significant infrastructure, and so I'm happy to leave that here today, but I've expressed my preference. My evidence really is dealing with some very small things, and this is one, and it's about figure 1, step 2 in the general approach. I think the Section 42A report is correct in this regard. The national grid yard is not an overlayer. But then I've had a look at what the national planning standards say, and it is a feature. And I've just suggested a small solution there that kind of makes that figure work a little bit better by referring to features and then just referring to the transmission lines, which are the feature on the planning maps, if you like. Another even smaller matter, perhaps, the definition of land disturbance. I just note that it is a national planning standards definition, and in my view, it should be shown as such in the definitions. And perhaps the bigger issue for Transpower at this hearing is SD02, Objective 02. You've heard a lot about that this morning and possibly yesterday as well. My evidence really notes it's one of those exception bespoke provision sort of cases because the national grid is not subject to the MPSIB. And so in the 42A report where amendments were made or suggested to you to Objective SD02 to give effect to the MPSIB, that has an impact on how the exception applies. And so this is happening a lot in a lot of district plans across the country. I'm doing quite a bit of evidence on this at the moment. And really, I come to the conclusion that and I do appreciate that it seems really clunky to add, but the national grid this, but the national grid this, but this is one of those circumstances where I think it really is necessary. And I was pleased to have the benefit of hearing the opinion of the planner representing the Director General of Conservation today. And it appears that we agree that the MPSIB doesn't apply. We agree that where the national grid and Indigenous biodiversity overlap, the provisions that you might form about that should be informed by Section 6, the MPSET, and the Regional Policy Statement, not the MPSIB. But where we diverge is that I think that the strategic directions being the overarching provisions, if you like, unless they acknowledge that exception, there's a potential conflict and tension and uncertainty when you see that strategic directions objective alongside the more specific provisions in other chapters of the plan. And to me, that uncertainty was like, okay, how are we going to interpret this when the plan's being implemented? There's effectively competing outcomes and objectives or policy directions and policies if it's not resolved. And in my view, it's the job of the plan, and including at strategic directions level, to resolve those conflicts and eliminate that tension wherever possible. And this is why I've promoted a solution in the clunky category of National Grid's. National Grid's different here, but nonetheless, I think it is essential so that the National Grid is set apart from provisions that give effect to the NPSIB. Turning to the last matter in my evidence, objective UFD1, I've suggested amendments to this objective for a number of reasons, but primarily it's clarity of drafting. I don't think that the amendments that I'm suggesting change the intent, although what they do as a whole is give a little bit more breadth to that strategic objective, again to ensure that all of the provisions that come in the more specific chapters of the district plan are captured under the umbrella of the strategic directive, or strategic, or UFD objective, if you like. So that's the primary reason, like drafting, just some clarity in drafting, and to ensure that all of the range of responses for incompatible activities would fall within that outcome that's prescribed in UFD 01. And that's it. I told you I'd be brief.
Thank you. Can I just jump in there, and just in terms of the drafting technique, did you consider whether or not that you could maybe amend SDA 8 and kind of reverse engineer make it clear within that objective that those aspects that relate to the NPSIB don't apply? Is that another, I'm just thinking, efficiency of drafting, but also, we've had a number of submitters who have come to us and asked for add-ons when there are specific objectives relating to a particular resource management issue, perhaps the approach could be to leave those as uncluttered as possible, but where there are genuine exceptions, you create the particular policy framework or objective framework around those.
I do think that that's a good solution. It's just making sure that when you come back later to read the whole of the plan, that you're not creating tension between that one, and it's really clear to plan users that this is the direction you follow in the case of the National Grid. And yes, I agree, it can be achieved in a National Grid specific way elsewhere. Yeah. Mostly my evidence here was probably responding on the fact that this is where the NPSIB kicked in, so that's where my evidence came, yeah.
And also just in terms of sort of a more sort of national approach to this issue, how's it playing out in other district plans? Are you essentially seeking the same relief time and time again, or is there a more elegant solution that's presented itself in other environments?
It depends on the starting point. If you're at the draft phase of a district plan, you can probably have more dialogue about getting it really nice and tight. It's when you try to fix things by submissions and then evidence, and even worse probably by mediation, that it starts to get more and more inelegant, if you like. Depending on the stage of the plan process, it's playing out more or less clunky. And probably I'm also mindful of the fact in the long run, this may be resolved by the fact that the NPS-ET is being reviewed. No, it's the government, so I'm not sure what the timing is or priority is, but hopefully in the long run, the direction will be more clear. But in my evidence, in a number of district plan hearings at the moment, it is saying, hey, but don't forget you can't do this to the National Grid. There's this exception. Yeah.
following on from that, the comment I had was, I think your clause X, I found it quite tricky to read and actually understand in terms of the change you're seeking to SD02. And I would be quite interested to see what you might do or what drafting could perhaps occur if it did happen in a different strategic objective. So say the infrastructure one.
So in terms of SDO2, yeah, I'd be really happy to have a look at that and come back with a suggestion.
Because I have found it quite challenging, and my question was, I just really wanted to understand what it did actually mean, because I did find it a bit more challenging.
Yes, okay. I'd be very happy to have a look at that.
Thank you.
No question.
I just have one question for Ms. Shan, but before I ask my question, I just wanted to point out that yesterday morning the reporting officer did update their summary statement to say that accept the shade part for that land disturbance. So
good.
That was recommended. But my question for Ms. Shand was, first of all, the evidence was really good, and I got a great understanding not only of Transpower assets now, but also future New Zealand. So really helpful to understand. At paragraph 5.7, you speak to South Canterbury, and you talk about the regional peak demand here and the forecasting for it. And what I couldn't get an understanding of was, you say over the next 15 years it's going to increase by 2.7%, but the national average growth is actually 2%. So what is the difference for this district?
That's right. So at Transpower, we break out our network into regions, and so when I talk about the South Canterbury region here, that doesn't match any particular district boundaries as such. It's a sort of a line on a map that Transpower's drawn in the general South Canterbury area, with our assets included. So we look at that wider area, and we've recognised there that there is going to be growth within this area, slightly above the sort of national average, which is that 2% mark. Within the Timaru district itself, we can look at what's predicted for the two substations that we have here, which is Temuka and Timaru. So you'll see there I've got that we expect within the next 15 years, we predict that there will be a slight increase in the megawatts required from those substations, only slightly at Temuka, from about 70 to 73, and at Timaru, 114 to, sorry, it might be you're on the wrong way around there, 112 to 114. So just slight increases in the load predicted there, with urban growth and new industry coming on board potentially. Transpower looks at the asset management plan which Alpine Energy produce. So we get a lot of our load forecasting for the area from their information and what they're seeing work, and that helps us plan for what we need to do at our substations or on transmission lines to enable any additional capacity.
It sounds like predominantly urban growth, but because I thought there was a link there to some types of farming practices.
Yeah, so it could be, again, like the dairy industry I've got there, or irrigation, with processing changing to, or like decarbonising and changing to electrification. We expect there to be greater load growth there as well. So something like a Fonterra plant looking to decarbonise and switch to electrification, that would definitely be increasing load on the network here, and we'd have to respond.
Thank you. A question for Ms McLeod. Heading back to SDO2. I was wondering, is there another way to secure the kind of further clarity that you are seeking? For example, some advisory or interpretation notes in the beginning of the strategic direction chapter, rather than amendments to the strategic objective itself.
Another way this has been achieved in some district plans is to, when you get, and this may be more of the kind of scenario that Doc might prefer, or the Director General, is to, when you get into the infrastructure and energy chapter, and there are national grid specific guidance, and particularly policy that manages the effects of the national grid, often provisions will include a carve out there, if you like, and say, this is what applies to the national grid, and then you'd have SDO2 does not. Like, you could do it that way. Yeah. Would you like me to have a draft at that plus the, yeah?
That would be much appreciated, because I think if it's achieving the same outcome that you're seeking through the relief you've presented, that would be quite interesting to see the different options quite clearly and compare those.
Less clunky.
Thank you.
Thank you.
There's Groundswell. Jamie McFadden. I think, is that online? Yes.
Hello there.
Welcome. Just make a start when you're ready.
Okay. I've just got some, I might just turn that volume down. I guess our submission is quite high level in that we're looking at the Timaru district plan in terms of how the different planning instruments will or won't work in terms of delivering those outcomes on the ground, thinking of the purpose of the RMA Section 5. My sort of lens on this issue, while I'm Groundswell NZ environmental spokesperson, I do have a bit of a background that gives me a different type of lens. So I'm from a hill country sheep and beef farming background in North Canterbury. 6 years on Federated Farmers, 6 years on the Huranui District Council, 3 of those as the environmental chairperson. In the last 25 years, well, my wife and I actually celebrate 25 years this year with our business, which is a native plant, eco-source native plant nursery restoration business. And we have done, over that 25-year period, thousands of environmental projects. And we've got over 300 clients, mainly farming clients through Canterbury, some in Marlborough. And when I sort of put a lens on these issues, it's looking at it from the whole aspect in terms of the RMA, what the RMA is requiring, what the district plan's saying, and then what it's actually delivering on the ground. So most of my work during the day is working with farmers on the ground, and I see daily how these different mechanisms work or don't work on the ground. So I guess I provide quite a unique view in that sense. And that is the thrust of this Groundswell submission, is looking at those outcomes on the ground. If I go to Section 5 of the Resource Management Act, and it talks about the social, cultural, economic and environmental aspects. A key point in our submission is that the policies we're referring to, especially those Section 6 policies, they fail on all those counts. And just in terms of a couple of those, the social side, I think that often gets forgotten, is that the social cost or the social impacts of Section 6 matters, and we've covered some of that in our points 3 and 8. And interesting, talking to one of the Timaru families affected by the SASMs, and the sort of dispute that it can bring into families where certain members want to challenge a provision or a policy, and other members don't have the energy or would rather focus on carrying on with the business. And it does bring, we're seeing this more and more, it does bring a level of dispute into families. And I think that's quite important with point 8. where we talk about once a property is classified under one of these Section 6 matters, it really does throw those property owners into a, well, I mean, having been through it ourselves, I mean, I would call it a curse. It's like a curse on you when your property is mapped into these classifications. Just on the environmental aspect, why it's failing on the environmental aspect, we presented quite a lot of evidence at the Huranui District Plan review in 2016, and we demonstrated why the mapping of SNAs and the regulations were failing to achieve the purpose of the RMA, particularly around protection. And the Huranui District Council agreed with what we were saying, and all mapped SNAs were removed from our district plan at that time, and there were no appeals. I guess a key question is the question around how is protection achieved, and there's sort of this view that you need rules to protect, but it would be good to have quite a lot of debate around or discussion around how do you actually achieve protection, because that's fundamental in terms of meeting the purpose of the Resource Management Act. And how do we actually gain on the ground protection of natural and cultural values on private land? And how does council recognise and provide for this in their planning processes? Just the final points are solutions. And in talking to another one of the family farmers down in Timaru, and I think he put it quite simply. He said, you know, it would have been nice if someone had come to us and acknowledged the work that they had done as a family in terms of protecting rock art drawings on their property, and you know, acknowledged over family generations have retained those rock art values on their property, and then said, how can we help you, rather than being thrown into this planning framework of mapping and compliance and uncertainty. And I think that sort of summed it up quite well. And one of our key sort of planks or solutions that we're looking for from a groundswell point of view in terms of natural and cultural values on private land is how do we empower people in environmental stewardship, guardianship, to looking after these natural and cultural values. And yeah, I'll just finish there.
Thank you, Mr. McFadden. Look, just a comment and a question for me really is that, I mean, you'll appreciate from your background in district planning processes that the panel needs to be focused on what the decision or the outcome is that you're seeking and what changes you are seeking to the district plan in response to the submission that Groundswell's made. And I don't see that in your written submission that you've lodged. Have you thought about what is the relief that you are seeking from this panel?
Yes, I guess the relief we're seeking, and we're actually up in Wellington today asking for the same relief, and it's really to have a reflect on Section 6, and as part of your district plan process, reflect on whether the planning mechanisms that are being proposed are still have merit in meeting the purpose of the Resource Management Act, and particularly around things like SNAs and SASMs. And what we're saying is that clearly the evidence that we're seeing is that the policy of classifying land using mapping and a regulation does not work. Therefore, that policy should be rejected. And that's our first submission, is that any of those policies and this idea of mapping Section 6 areas should be rejected. That is our first preference. And then we've outlined some other suggestions there in terms of pausing those aspects relating to Section 6, because new SNAs have been suspended, And in discussions today, we understand that the government are also looking at these other Section 6 matters, heritage, SASMs. So yeah, I hope that helps.
Thank you. I'll just check in with the other commissioners.
So I just have one question, and that is around, so I heard you say that the purpose, or one of the main key reasons you've submitted, or groundswell you've submitted, is because to empower people to protect the environment is what I have written as a quote here. And so I think, well, and then on the other hand, you're saying, however, no mapping. Don't map things. Don't map where the things are that need protecting. And so I don't understand how you relate empowering people to protect the environment without actually being able to understand what's there to protect.
Yep, so if you look at the Huranui District Council example, and what's happened there is that the mapping is all gone, but what the District Council are doing is that they are supporting biodiversity outcomes through they've got a biodiversity officer, but also a lot of support behind community initiatives. So we've got a land care group that covers 75% of the farmed area in our district. We've got a Huranui Biodiversity Trust, which I'm one of the founding trustees. We've got lots of different mechanisms, quite exciting actually, in this space, because there's a lot of work happening in the space of Indigenous biodiversity and environment generally, fresh water quality. There's a lot of water quality work going on. So it's you don't necessarily need mapping to protect values on land, because the other way you can do it is a bit like we work as a business. We'll go onto a farm or a property, we'll go over the whole property, we'll spend some time with the landowners, and we'll identify key values that we see on that property. And then we either we find different mechanisms to help the landowners protect those values. So we work closely with the QE2 Trust. We work closely with Environment Canterbury with their land management team. And what we're seeing is lots of positive outcomes for the environment through that approach, rather than necessarily mapping areas.
Okay, thank you for that answer. And I have seen that you can do pockets of environmental restoration or protection, but I just don't know how appropriate it is for this particular district, given how proactive they have been so far over the last decade or so, of already identifying Indigenous biodiversity, and how appropriate would the Huranui system be for this district, when we've heard a lot of evidence so far about how it's been proactive for a decade or so?
Yeah, I guess what we saw with the SNAs was it has had variable responses around the country. We had, the far north, and there's been quite a few districts that it's been a highly contentious issue. And our submission covers both likes of SNAs and SASMs, and what we're seeing with SASMs around the country now is the same as what we saw with SNAs in those early days, or even more recently with the far north. That wasn't so long ago. And what we're seeing is that they're quite disruptive policies, these Section 6 policies, when you map or classify over people's land. And what we're seeing with SASMs, Waitaki, West Coast, Timaru, across the country, is this community upheaval. And what I guess with the SNAs, and that's why we see it as much as a national issue as a local issue, it goes back to what I was saying before, that SNAs, even in Timaru, it's not the mapping and the rules that protect these areas. I mean, a lot of the good work that's happened in Timaru that I've picked up is when there's been one-on-one discussions between the landowners and the ecologists, and it's those flow-on actions that are actually generating the positive outcomes, not actually the mapping and the rules.
Good afternoon, Mr McFadden. I want to talk about your submission. I want to go through your submission. I've got some questions for you around your submission. At paragraph 3, you say that property owners, you don't exactly say they value cultural values, but you certainly say they are. By removing the values, you talk about how some property owners have been forced to remove cultural values from their property. Is that right?
Yes. Yep. Natural and cultural values.
So by removing them, does that demonstrate respect and appreciation for them?
That's an interesting question, because what certainly from my personal level I find is that it's quite challenging in some situations, because the landowners are so annoyed that they forget, I guess not forget, but it lessens their enthusiasm to value those values, and it lessens their enthusiasm to look after those values. And some landowners, they don't lose sight of that, but for others, they get swamped with the uncertainty and I guess the fear of what this all means. And I'm also probably, I like to be quite frank with what's going on, and there is discussion amongst not just landowners but contractors, and there is a reasonable amount of discussion around the country about what happens if there's contractors, building contractors or excavators or whatever, that you come across natural or cultural values, and there's a fear now that it will open up a can of worms. And so that's why we say that what we're seeing with Section 6, it's actually undermining those values.
So that implies that you understand cultural values if you think they're being undermined. Is that right?
Oh, well, from my personal point of view, and I mean, when I sit around with our groundswell guys, I mean, they're all quite environmentally conscious in terms of the crew that we've got, and certainly from my point of view, I mean, the cultural values, they haven't been well respected in the past with some of the things that have happened, and we do need to respect those cultural values, those cultural and natural values. Yes.
So do you consider that by removing cultural values from properties would engender trust and support for a non-statutory approach, and particularly Groundswell's environmental policy framework?
Yeah, I look at the issue from, where do you get the best positive outcomes for those environmental, natural and cultural values, and in terms of meeting the purpose of the RMA, and you get those far better. I mean, you always have one or two people that will, destroy things. Fortunately, that's getting less now over time, but overall, you get far better results with actual protection on the ground if you've got the buy-in of people and you respect those people. That respect goes both ways, and they're empowered to look after those values. And that's why I say what we've learnt with what we do, working with farmers right throughout, Canterbury and parts of Marlborough, is that that's how we're really making progress on getting particularly natural values properly protected.
I mean, I don't doubt that on the ground definitely works better than, but I want to talk about voluntary versus regulatory. Have you considered that mana whenua rely on council and the regulatory system to assist them in protecting their values? Because to date, if it had been relied on by the goodwill of, say, groundswell members, they may not have got any traction because they didn't in the past.
Yeah, one of the things that we're highlighting now is that we're in quite a different space now. And when we look at the momentum shift amongst farmers and landowners, it's huge what is going on now. And so the argument has shifted because there's a lot more, it's actually just sitting there waiting to be enhanced in a much bigger way than what we're doing now. And so this debate around Section 6, it's a different debate today because we've got so much more engagement from landowners and farmers. And so what we're saying is that if you had a policy that had I don't know, it might be the Timaru Council might have a cultural advisor, or like they've got with Environment Canterbury, and you spent the equivalent amount of funding with that cultural advisor going out to the different farms and talking to the farmers about, a bit like the land management team operate in Environment Canterbury, you would get far better positive outcomes in today's world than you would with this approach, which is outdated.
Can we go to your paragraph 11, and where you say would be counterproductive and will only serve to demean those cultural values even more? When you say demean those cultural values more, who do you mean will demean them?
What we mean there is the policy and the policy mix, or the planning mechanisms. That's what demeans them. It's not people demeaning them. It's it's the planning mechanisms.
Have you read a report? One of the background reports from AECL provides a schedule of identified sites with a description of the location and values of each of the identified areas. Ara whenua hold valid concerns that if detailed information as to the specific location of the site is provided in a public forum, that sites could be destroyed and or vandalised. So given your statement where some landowners remove, you could understand why they don't want that information to be known publicly. Can you understand that?
Yeah, I understand that, and it's an extraordinarily sensitive issue because of, I guess, what's happened in the past. Yeah, it's an extraordinarily sensitive issue. Yeah.
So you could perhaps appreciate why it might take a while for mana whenua, for instance, to come on board with the non-statutory approach.
Yeah, I can understand that. Yeah.
Thank you.
Yeah.
That's all the questions from me.
Mr. McFadden, just for clarity, are you representing Groundswell nationally? A lot of your commentary today has been your own personal view. I just wanted some clarity. Are you representing local Timaru District Groundswell members or Groundswell nationally, or are you submitting your own personal view?
No, the submission's Groundswell NZ, so from the national body, and that's consistent with our views. Yeah.
Will you, going forward, have local representation? It's really important that the views are locally driven. I feel some of today has been your examples are of other districts.
Yes, we've used some of the examples from other districts as evidence, and we've taken steer from the feedback we've had from Timaru farmers, but we don't have local, we're a voluntary organisation and we rely on people to feedback into us their concerns, and we go from there.
Thank you, Mr McFadden. So you will appear again before the panel. Is that your intention, that you will present at later hearings, or is this the opportunity you wanted to present your submission?
Well, we're pretty well covered it. Yes.
Okay. No, thank you for that.
Yep. Yep.
Thanks for your time this morning. Thank you.
Okay. Thank you.
This hearing stream. Was there anything that the council wanted to raise with the panel before we conclude?
Thank you, Madam Chair. There's a couple of things. The first thing is just to reassure the panel that we are putting in place mechanisms and procedures for tracking the issues that sort of come along, and hope to be able to sort of provide that to you at the beginning of the next hearing. The second thing is that it's been occurring to us that it might be quite a good idea to map the reverse sensitivity policy provisions from the national policy statements through the regional policy statement and then through the district plan as notified or as modified by the Section 42A report. And just wanted to sort of check in with the panel about whether that you would see that as useful. And if so, whether there's an opportunity perhaps to work with Ms Thorne to get her feedback on the format of that and make sure that it's in a format that the panel, that is useful for the panel.
Look, I mean, obviously it's a live issue for us to make sure that we understand how those higher order policies have tracked through the district plan. I think probably at this stage we might just want to reflect on that, because we might have more specific questions of the council on those issues. Thank you for the suggestion. I think we will just take that thought away, and perhaps we can communicate via a minute more formally with you about what might help us in that sense, rather than doing it on the fly.
Sure.
If that's helpful.
Of course, that's fine.
Because it may be something we want sooner rather than later, you know, not just as a sort of right or reply matter. It might be important for the hearings that are coming up as well.
Yes.
So.
And so just on the right of reply, I just wanted to check in with you around your thinking for that. Are you assuming that we would reply to the issues from hearing A before hearing B comes along, and we sort of tidy those up as we go? Or at least provide it.
Question. Look, the final right of reply will be at the end. I think where we've probably landed is that a number of the issues that the council office or Section 42A officers have signalled as still being live are kind of interrelated with subsequent evidence. So I'm just wondering whether we don't want to jump the gun. If there's some obvious corrections or shifts in position that are really no longer disputed or not influenced by subsequent evidence we might heard, by all means we're happy to receive a supplementary or updated 42A report, and it'll come to us and go up on the website, so all submitters are aware of that. But I don't want to generate unnecessary supplementary statements that then get amended and amended as each round.
Yes, okay, yeah. That makes sense.
So is that helpful? I think we just need to sift out those things, and I am thinking about the reverse sensitivity, those drafting changes to the strategic objectives. I just wonder if it's premature to be going down that path, but if submitters have raised matters of error that are obvious and can be tidied up, then let us know sooner rather than later.
Yes, I think we were thinking about where because obviously in the summary statements, both of the officers signalled that they'd like to hear sort of submissions before they formed a view on whether there should be any amendments. But I guess we were sort of anticipating that we might have the opportunity to identify where Ms Hollier or Mr Willis now might agree or still disagree for the moment.
Yes, so were you thinking that you would do that in writing after today rather than yeah, I think that could be a helpful step in the process as a filter for us. I know that we'd flagged at the beginning that if the panel had wanted to circle back and ask questions of the 42A officers over the course of these 2 days, then that opportunity was still there. I'm not sure that there is anything particular that you wanted to raise now.
I had some, but if it's going to actually, because they were live issues identified saying that you wanted further evidence or to hear the evidence, and so I think they're exactly the same things that you've suggested.
So
Happy to do it in writing.
I guess I was going to suggest that if after going away and doing some deliberation you had some specific questions that you would like the officers to address, we could address that in some supplementary evidence alongside indicating if there are any areas of agreement, for example.
Yes. And I think that would be helpful for the submitters who have given us a sort of highlights overview of their issues this week and are clearly going to come back to us with more substantial points. It would give them a clear indication of where the 42A officers may still see that gap. Yes, I guess it's been an interesting week generally in terms of whilst the structure of the hearings has obviously been predetermined in terms of the order of hearings, there's that significant interrelationship, and we are in one process. You know, ultimately this is about delivering decisions on the plan at the end of the process. So we're just finding our way really about what works, and some of the formalities around hearings, timing of 42A reports and responses is something we're just really finding our way on. I don't think that we can, it's not necessary to hear from the officers now today. I think we'll take on board what you've said and come back to you in writing and perhaps just give you a week or two after we come back to you to respond with some supplementary 42A commentary. That would be helpful.
And just on the timing, I just wanted to signal as well that all of the officers are involved in preparation for the next 42A reports and that kind of thing. So I was going to suggest that sometime around mid-June might be appropriate, which would be sort of 5 weeks from now and 5 weeks in advance of the next hearing. If that's too long, we could have a look at sort of what other timing might work. But I just wanted to signal Mr Willis is obviously on the hearings panel for the Mackenzie hearings, which are about to kick off, and Ms Hollier is preparing her 42A report for hearing B. So there are a few sort of constraints on the officers, but obviously we'll
take that into consideration.
Absolutely. And similarly, if there were any legal issues that arose that you'd like some further commentary on, I'm happy to sort of provide that. You know, I was sort of thinking potentially around the inconsistency and giving effect to, if that would be helpful. But I'll just leave that to you, and if you have some specific questions.
I think we'll just leave the legal submissions. We appreciate your role in terms of providing that entry to the process, but we've also got a lot of submitters who are also going to be legally represented and will give their views, and it may be that there is a role for that at the end in terms of right of reply. But, but thank you.
Thank you.
And is there any other matters that panel wish to raise? We'll talk about site visits. We, just in terms of site visits, that's probably something that we should get on the record. Prior to starting the hearing process, the panel did have an orientation day where we pretty much just did a bit of a tour of the district so that those of us who are not as familiar with the district have an opportunity to get an appreciation for the scale of the district and the mix of activities across the district. But we will endeavour to, as the process goes through, to undertake specific site visits, and as a result of this week, I think certainly around visiting the port and understanding the environments of the port of Clandeboy and the waste management facility are at least on our list or on our radar of places that we would like to visit as a panel. And individual submitter issues may come up as well to be added to that, and we, if there are areas that you think would be helpful for the panel to visit, we'd be happy to receive a memorandum from you on those. Yeah, but really just to signal that that's our intention to do that. And we will undertake some of those ahead of the next scheduled hearing round. Thank you. Is there anything from your perspective? Okay, well, we'll... I've already asked. Thank you very much for your attendance. We will close with a karakia. Thank you.
Kia ora tātou. We'll close out today with to celebrate our first week of hearings, and to close we're going to, and to make sure everybody arrives safely home. Kia ora tātou, kia tātou katoa, te atawhai o tātou ariki ihu karaiti, me te aroha o te atua, me te whiwhi ngā tahitanga ki te wairua tapu, ake, amene.
Kia ora.